Yes. Yes, Bothagur. Wait for your turn. Any interim order? Wait for your turn. Yes. What is the matter about? This is a matter of 2016. Any stay order? LCR, scan copy or original LCR? We'll see. Now for the time being, prayer for adjournment rejected. Yes, we'll see later. We'll see when meta reaches. Yes, next. Yes. Okay, on the prayer of the Learned Council for the meta stands adjourn and be listed after 2 weeks. Yes. Yes. 30? Any interim? Yes. When Bothagur? 10th of October, interim to continue. City is not, city is eventually.
Motion B, item number 1. For withdrawal, item 53.
Granted by law court. Dismiss on withdrawal.
Item 1, motion BA.
Yes, but how absolute rubbish. Absolute rubbish. Considering where is the affair? Huh? This court has also considered detention period of detention. This court also considered that the allegation also considered that the informant allegedly was lured for the first time and she was raped, and after such commission of offense she were again lured for 3 times to do the same act. We should not make comment again. It's a case of crossing anyway, which in the considered opinion of the court, okay, not let us say all this. That may again create some problem. Allowed to the satisfaction of Kanro Petro. 50,000.
Item number 2.
Yes. Same Bothagur. And then what happened? And kindly see. Then marriage, then refusal. What is you want a CD? Is it a case for CD? Tell me. On 7th will allow it. Okay, for that you want a CD on 7th will allow it. CD on 7th. Whether CD is there or not.
3.
This is not a case of 376D. Let her go, let him go. Allowed. Why a person should unnecessarily be for next 7 days? To the satisfaction of SDGM Bokajan 50,000. Yes.
Item 4.
Huh? 3.
Allowed.
CD. Huh? Two dilu. 1 and 2 we have granted. 3 is CD. Nice. But when? 19th.
4.
Yes. CD. When?
Motion AB, item number 5.
Okay. Arrested. Okay. It is submitted by the learned counsel for the petitioner that petitioner has already been arrested. Accordingly, the present application stands closed. So the petitioner may file regular bail application if so advised.
Item 6.
Where CD interim within 10 days. October 12th.
Item 7.
CD interim. When whatever.
Item 8.
Case diary. Or facilitated. What is the search sheet? Then how do you know? Where have you mentioned? A scanned copy of the LCR and the case diary of
Case diary of WPS case number 74.
we call from the CGM Dhubri in connection with GRPRC. What is this?
Police case number 74.
No.
Here case number 217.
Silo. Pending before the CGM Dhubri. Give a date. 27.
9.
Yes.
Page color relevant is the FIR minor. And guard statement color page.
If non-bailable warrant issue or you want anticipatory bail.
Color the warrant issue.
Warrant issue, a college issue, anticipatory bail. Relying on 2 judgments that even after search sheet anticipatory bail can be granted. 25,000.
10.
Yes, case diary. When but out? Yes.
Item number 54 of supplementary list.
Mr. Bora, we are not inclined to for interim.
My FIR.
I've seen that.
I have lost an FIR.
Hmm.
Again, give my lord,
Hmm.
the page 27.
Specific allegation is this, that on such and such date, I was treated and immediately thereafter dead body was found. This is not a case for interim.
2 days prior to that, there is a check-in file.
Yes,
This is a case of registered under, it is not a 302 month. It's a case of registered under 306. Abatement to commit suicide. Had it been a case of 302, I can understand. He has committed suicide, madam, here. And
we do not know.
No, that's the,
We do not know.
no, that's the, madam, 306 has been registered.
Maybe, but allegation is specific that
Education by the wife initially, that they had a suspicion that they might have killed him. Then when the body was found, thereafter case has been
body was found where?
registered. Somewhere else.
Where? And in what condition?
That's it,
Not
that is
hanging,
why-
nothing of
No,
that
no,
sort.
that is why the 306 was registered. And in my, what is the reason for checking? Absolutely, follow the, what happened, my logically.
What about when can you have Borpeta?
No, any-
On 7th,
some 39,
be a little bit earlier because we are not no interim.
on 12/9 and 22.
10th,
Yes, on
10th,
10 holiday only,
10th holiday,
some day only, on 12 I will put it,
11th,
11 days.
11th.
Item number 55,
CD interim, when?
On my, 12 of October,
12th of October. Huh? 11th, along with
11.
we'll call for the case diary, on, CD interim on 11/9. You get your statement recorded.
Okay.
Yes.
56,
Yes,
Second time before, your lordship, madam, earlier order rejected by, my lord justice Sushmita upon house.
so let it go there.
My lord is good, available in the.
She's sitting in division bench. I think she's sitting today single.
The division bench is not available. Today I had asked my lord for it.
So what is the provision now?
Then if the bench is not sitting, your lordship may take.
We'll call,
My lord, already earlier rejected, your lordship may-
we'll call from the case diary.
My lord, already two ways, many to serve, my lord, or behind the power matter. And it's earlier rejected, my lord.
Earlier rejected, that is the problem. In fact, I cannot touch this file.
After rejection, my lord, the,
On a minor, she just is a constituted bench because she is available here.
yes. Technically, confined, then my lord, the bench is clear, appropriate.
Appropriate bench because she is sitting today to deliver a judgment. At what time? After rising of DB1, make a mention and get it unlisted that this is here registry. I have no problem. This matter, let this matter be listed before the appropriate bench. Full stop. To make a mention, if permission is granted, we'll send this file.
I did make it.
57,
Yes, electric, they gave electric fencing.
I know, this is not, we are denying on that. Why can
Why
deny?
do you have, my lord, fixing that electric fencing in the.
No, they deny, we are denying. No, they are.
Not-
Thought that I put it with you.
Yes, that.
On, 39.
13. We'll examine what is what.
Okay.
CD 13.
Okay, I prefer 2% because they have some problem. What get for exclusion, we can get something. That is separate for only petition number 1. That will be a private property.
Okay, petitioner number 1, because
30%.
intention may be different not to kill
Yes.
accident is ultimately, but accident is contributed by you. So interim in respect of petition number 1. Consider petition number 1. But you appear and give statement.
Yes, there is.
58,
Huh? Item number 36, bail hearing. Okay, we'll take along with 36.
36 is very no.
So here we'll call for the case diary, fix it.
Only 2 ladies are there. Let us want-
Is there any privilege for ladies in fact so far relating to crime?
The main FIR, stage number there, the accused number of.
This is not a case of interim
Just 2
specific allegations. No, sorry. When what happened? 59. CD on you just 36 also on 59 then just note it down.
Yes.
59 case that.
Motion, item number 12.
This order in the page 33.
311.
No, there is a Jimma, now detail.
Okay. Now the Jimma has come. We'll take a little bit later. Huh? What about?
Yeah.
Let us finish other Jimma one by one. We'll take up. After later. Jimma to we'll keep it here.
13,
13 also same.
14,
13 will keep a little bit separately because 13 is the question of 451. 13 rejected only on the 451. So 13 will here with the state appeals. Okay, now 14.
No.
This is 311.
Find out any judgment,
Hmm,
whether that can be taken as lacuna,
hmm.
because the counsel for the dispute, they failed to.
See, confronting with the otherwise for ends of justice, my view is that that was important. This otherwise court faces a difficulty that you have not confronted. Every day we are getting it, Mr. Das. His case is that the petitioner has not stated these facts before the IO. Whatever, there is some improvement. So that he realized at the stage of argument, maybe while reading or for the argument, preparing for the argument, he could see that 161 is something different. Testimony is something different, and that was not confronted. Now he files an application on to examine one witness, isn't it? Only IO, only IO.
PW 6 and 7 also will make to be called for.
No.
Your statement has to be contradicted.
Then through the IO,
Only
that
to prove the contradiction.
to prove the contradiction and to exhibit 161 statement, is that it? Now we put a question whether this will amount to filling up the lacuna or whether we can treat it to be an action which is necessary to arrive at a just decision. My view is that this is necessary to just arrive at the just decision. But stage is because if we say we'll have to give reason why in this case. Otherwise, in every cases, people will come. We have dismissed, in fact, one petition. People will come and say, oh, this point was not cross-examined. I want to cross-examine. We have, in fact, rejected a petition on that ground. Now,
There are 8 documents here, almost similarly situated.
there is a judgment by Honorable my Lord Justice Gogoi. In a different context, that judgment was on the issue of non-confronting the 161 statement. While my lord was a judge as of this court, with this court, a division bench judgment, where it is said that this mistake of cross examination is a common parlance in this area of our state and all northeastern states. So criminal trial and all are not in that advanced stage. Therefore, court even went into a position that court can look into 161 statement even if not confronted. So once that is important, you also see that judgment. Where is the next date fixed?
14th of February.
Have we passed any stay order
No,
on 14th of?
September, yeah.
We'll have to pass the reason judgment in this case, because in here it is a
Ethics code is very strict regarding.
wait, that's
Ethics code has say that the ground of scales of justice
Hmm.
cannot be stretched unlimitedly.
unlimitedly. Therefore, why I'm
Scales of justice cannot be stretched unlimitedly.
unlimitedly. Now here question is, whatever judgment we pass, this will be a binding precedent for all the trial court, isn't it?
No.
So every language of this order should be, if we allow, if we dismiss, there is no problem on that. So let it be taken up on 9th or 10th. You have the judgment. I think we passed that. We relied on the judgment. Mr. Das was there. In case of a boy, see, he took his girlfriend in a auto van, Morigaon. You were there, and Mr. Mahajan Junior argued this case. We acquitted that person. This confrontation were not there. So your judgment is more particularly specific to public prosecutor. So you want that benefit should be given to the defense also, because defense is case should be proved.
Shortfall and lacuna are two different. There is the shortfall that the trial court counsel could not confirm the statement. And lacuna is what is the inherent defect. And that.
But if this judgment we repeat now,
Here.
the adage to err is human is the recognition of possibility. If everybody, then what is an error? What is an lacuna? We will have to distinguish.
Yes, lacuna in prosecution case is not to be equated with the prolong of an oversight committed by a prosecutor.
Now, what is oversight and what is lacuna?
That was the oversight because he could not confront the.
That is a-
No, he could not.
We will have,
It is not there. The
What-
purpose-
because of
Whether
oversight.
he has been, cross-examined at length or not, that has to be seen. That has to be seen. If he is cross-examined, according to their plan, then that ground will not be.
Because of the oversight. That was what my submission.
Cannot be ground.
so can oversight not be a lacuna?
Because human beings are prone to error. That is what the.
So,
Human beings are prone to error.
let me be fair. According to me, in the given facts, this is a case we might allow. But if it is becomes a precedent, that will create a difficulty. So what is the 311? In what circumstances we will have to exercise it, that are detailed things we will have to we'll deliver it. So you assist us on this, that what is actually 311, under what circumstances court should do, and what are these judgments, not only this lacuna, when it will be, court should do it, because court itself can also do it.
The time of his cross-examination, the date on which he was cross-examined, and when the petition for re-examination is filed, the time gap has also to be taken into account.
And my lord,
If he comes at a belated stage, that is not permissible.
and my lord.
See,
From the.
here reason is given. If proper evidence was not adduced or a relevant material was not brought on record due to any inadvertence, the court should be magnanimous in administrative criminalization. Suppose a forensic FSL report is not exhibited, as that happened in day before yesterday in some cases.
It is part of record.
Part of record exhibited by IO. The author is not here. No application has also been filed. In that case, I think this principle will be applicable. Now, whether there is mistake in cross-examination, that I have not asked this question, whether that will be a error or lacuna.
If that changes the merit of the case, then that would be amount. to
So let us have a proper deliberation immediately. In the mean,
Our synthesis way.
Hmm.
In a case court and customer is again. If lawyers illness
Hmm.
is no ground.
Hmm.
Suppose not a lawyer,
Hmm.
defense lawyer could not present on that case and he could not
cross-examine.
the case. That cannot be ground.
Mr. Arlam, you address us on 311. We'll go to your case. What is 300? Without being a lawyer of this person, you assist us. What is 311? Das and Bothakur is there. List this.
I would just like to point out one thing.
Yes.
Here in the, this is criminal injustice.
Yeah.
And you know, you also have to look into what is the illegal.
Yes,
And
yes, yes.
here from 11:05 to 47:23, they were totally silent. Till then, my lord,
They became wise while preparing for the argument.
yeah,
Then they saw that, oh, IO was, these questions were not put to the IO. 161 is not done, whether that can be allowed in exercise of power under 311. That is to be seen.
Profit is fixed on 11, profit is fixed on 14.
Okay, we'll fix at 11 and then you, if some not done, we'll pass an observation that you file an application, court will consider for adjournment. Since everything is over for argument. List this matter on 11 as agreed to by the learned counsel for the participant. Keep this judgment. I will also in the meantime do some research. Yes.
18.
Yes.
18.
Second application. Yes. Yes. Hmm.
After a month, having a notice 30. They have retained the, we have fixed.
Then
Then madam, this prisoner will do on the inspector and the agent, he is committed for it. I have not no power to grant bail madam, and will listen. For the. That's all clear. And this is the matter in one case of matter. Even matter high court drafted and bail matter. This is the matter. We will exist matter. Keep the filing of service. After filing service, the sentence will made us know. So this case is based on under section number 498A, is also the filing in 34. And according to SDB, there is no power to grant. Even though something one can never do better. Praise 18. Please 20.
every day we are surprised by many things. Don't be so surprised.
Please 20 one can never do.
Yes.
20. The success something by the I don't know. Please 20.
Yes.
Please 20. It's not a case.
Yes.
During investigation, the place of offense was visited and escape paper prepared. After according to the never engaged on this after going to the proceeding. Then another, I open it.
What is your bail order? Who will take out from the file? Not a part of the record. These kind of things surprises us. I told you, everything is surprise. The learned counsel for the petitioner is permitted to bring on record the bail granted by this court by way of an additional affidavit. List this matter on,
Next, that is on the.
list this matter on 9th.
I don't.
When? Then. 8. These are the surprises of life. You are also surprised. Yes.
Item number 19.
Where is your affair? Who is your senior, first of all? Madam, who is your senior? Where is he? He has some urgent matter today in a district court. So is he not in a position to appear before this court? Is it permissible? Ask your senior whether. Where is the affair? Page number? No, 48 is an order. On 2/8 also it was adjourned. This is not a case for quashing of affair. Any stay order? Any interim order? Huh? This matter should not be adjourned. 2016. We are almost on 2026. On last occasion also you have adjourned it. Kothakot have the status of investigation. There is no interim order. Also, the present application is filed. Will you decide which certificate is genuine, who is not? So, earlier also short date was given. Ask your senior that we will not do this. Present application is filed under so a sailing. Affair dated application is filed for quashing. FIR number 22224 registered on 22/9/2016 and corresponding to Gopur PS case number 224/2016 under section 468/420 IPC corresponding to GR case number 257/16. Sunset file, I think.
Yes, my circuit file. Here test number already. The circuit 53 of.
We are not inclined. When, and also the search sheet and the proceeding of GR case number 253/16 pending in the Court of Learned Subdivisional Magistrate Gopur. Full stop. This court perused the order passed by this court earlier and do not find any interim order protecting or staying the case. The scanned copies of the case diary as well as the record has also been received. However, an adjournment is sought for. Full stop. Such adjournment was also sought for on 2/8/2023, and the matter was accordingly fixed today. Full stop. Though this court is not inclined to adjourn such an old pending case, however, as it is expressed that the learned senior counsel, Mr. B.D. Court, is having personal difficulty today, the matter stands adjourned. Full stop. List this matter on 28th of September 2023. Full stop. No further adjournment shall be granted on that date, even if any difficulty on the part of learned senior counsel, and in such event, difficulty on judgment, inasmuch as the Honorable Apex Court, in a recent judgment reported in so and so, has observed that criminal petition can be decided in absence of the counsel or the petitioner and on the basis of merit. But
For bail hearing, item number 23.
yes,
Look at the last order, right? It is, but it don't have stayed, but it will come on the mind of your worship.
Medical report.
yes, status of the health condition.
So now also he has been shifted again, my lord. Idea, he was in medical college, there was can spend 42 months for the medicine. This comes up already examining, I will understand. I don't know.
What is your name?
My name is here in Manjur Ali.
Manjur Ali. You are?
And Manjur Ali come to the since my lord 31st July 20. 1 year. 1 month.
You'll have to go inside otherwise. You may have some respite now.
But actually,
But-
this condition is, yes, it is true, madam. Now
He'll have to go.
Now he'll go for it. Whatever is the only one I have only the six, only for six.
Specific allegation against him
Madam,
by
only for
the
treatment
informant and second cross-examination.
Only for the better treatment, my not for anything.
You are having the better treatment.
No, my God, this is for.
You want to go where?
There was kind of one stage 42, just about. He was initially to Techco Medical College. Then after what is BMC.
Now you want to go where? Tell us.
Madam,
You want to get treatment where?
personal care, madam, where doctor advice you will be taken. Maybe outside, maybe in the government to some expert, I don't know anything. For 1 month, is very impossible, madam, only for 1 month. But because can this pay 42?
No, we will come to that. We'll come to that. We'll come to that. We'll consider. If your health condition is serious, definitely we'll consider.
Pay 42.
Yes, now come to your health. Otherwise,
Pay 42.
implications, clear
I
implications.
understand you want. Pay 42.
Yes,
Pay 42. More soda.
what is your disease?
Mental violence.
Huh?
Cardio.
Huh?
Cardio and violence. And you also will see that person in handwritten. I was talking about I did the whole one. You keep in Manguari is not police because there. Judicial custody has to find them to be districtly informed that he is taking treatment at DMC. Since 21/6/23. The king to be representative council. He people coming from the. Only for a particular period.
Now, where are you?
I am now again. Again, in the hospital. Initially, you have for medical, last day, that day you are taken to jail. Again, he might have developed some disease, again, he was taken to, he is taken.
He is in hospital where?
This morning, from
Where?
Jubilee Hospital.
Chubri. Okay,
Some better treatment, nobody has got a problem. That is only for the purpose. It's
better treatment at Guwahati.
over. By outside, he cannot be taken because the financial problem also they are managed. Over the government.
Okay. We are giving you better treatment. We'll ask the jail authority to get you treated in a hospital in Assam, Guwahati, as per your wish. But cost is yours. Cost is yours.
But I want to take out of there so that I can take him, we can take him.
And we'll give a permission, one of the family member to accompany you.
Okay.
Your concern is the health concern.
The many members might not be ownership.
We'll permit 2 family members to be with him.
So that is the question. Once he comes out, by at least for 1 month or 6 weeks, my lord, it will give some kind of solace to him. That also maintains some sort of behavioral power.
Who will give solace to that person?
That's what I know this will that one. It will I also done some, but it will not happen about 4 6 weeks or 7 weeks. Once he is in the position.
The present application is filed for grant of bail primarily on the health ground. The record annexed to the present petition reflects that the present petitioner accused was could not be produced before the trial court when the matter was fixed due to his illness, and in the meantime he was initially hospitalized at Dhubri Civil Hospital and thereafter at Guwahati Medical College Hospital. On instruction, Mr. I.U. Chaudhary, Learned Counsel, assisting Mr. H.R.S. Chaudhary, submits that though he was, after some treatment, though he was back to jail, however, again he fell ill and presently admitted at Dhubri Civil Hospital and is going is under treatment in the state hospital. Full stop. Accordingly, the Learned Senior Counsel prays that the petitioner may be granted a temporary bail for his further treatment at Guwahati. You wait till 7th. 7th is reopening?
Yes.
Full stop. This court is of the view that if the petitioner is seriously ill, even he is an under trial prisoner, he will have a right to better treatment in a better hospital. Full stop. Therefore, this court is to ascertain his present health status so as to pass an appropriate order in this regard. Accordingly, the Superintendent District Jail Dhubri, as well as the Superintendent of
That's what I'm there to do, man.
Superintendent Jail, Superintendent Jail Dhubri shall give a let us have the report from the doctor and the Superintendent of Tezpur Medical College, Civil Hospital or Medical College? Dhubri Medical College or Civil Hospital? Civil Hospital. The Superintendent of Dhubri Civil. Then you'll ascertain, because I do not think there is a civil hospital. Now it has become a medical college. You have that. Submit a report regarding the present status of the health condition of the petitioner. Will, even if that is there, let us have it. Will allow you to have a list on 7th. A copy of the order be furnished to MS Das for onward transmission to the Superintendent of Jail as well as to the Superintendent of so and so, either hospital or medical college. Ascertain.
24.
And appears for the petitioner on call. List next week.
25 and 26.
Yes, madam. Yes, 25 is bail 2892. Shahidul Islam Allied Shahid. Where is the affair?
But it after it says one of the state minor 14 members. They arrested on minor 5/23 and it is there was today minor 29 days.
What is the allegation?
Allegation is minor basically land dispute. The minor 15 is the operating part minor.
Only one appeal is from
How many days you are inside?
Minor the today is minor 29 days. Arrested on minor 5/23. Basically land dispute between the minor two relatives to group matter. They are also relatives matter. Minor is a minor ancestral property. Both family initially entered, but recently the informants family members are protected to enjoy the petitioner family. Minor there is some minor confrontation between them matter. No serious minor injury minor occurred. And in fact, minor the informant side is about the petitioner matter. And the affair is minor is a closed affair. Kindly see affair from my side matter, our side, page 29. This affair was closed on minor 22/7. Incident on 2 days, initially 21, then again on 22. After to this 21 incident, the petition, accused number 3, lodged this affair. Operating part is page 39.
Others not so serious, but one was serious. Mofidur Rahman. Brain injury, hemorrhage with fracture, hemorrhage, then depressed fracture in right perineal bone, overlying scalp, head injury with head bone fracture. PDR come after some time. Only. What is the offense? 307. 90 days.
In fact, petitioner such is also serious minor injury. I have
Where is your affair?
My affair is page minor 29 member.
Page
Page 29. My affair is law number 22/7 and the informant affair law number 23 member. Fourth affair.
What is the case diary of this case?
Both the consent is possible.
only one to be listed.
In another case, my lord, both the questions, item number 26.
Not received. 26 is the case you have lost.
Same affair number, because these three petitioners are behind the bar, and in the item number 26, these are all members from outside.
But they will not get, even if 26 is FIR lost by whom? By you.
Yes, yes, both are the same matter.
Then this is the CD
This is the same.
in 26 also.
Yeah, 26 also, my lord, both the city, madam. They are only for the.
No, no. This is the CD in respect of 26 also. They are accused in same FIR. Riazul Islam. Let them go. Because you have collected documents, injury reports, statements recorded.
But time is our injury also, madam.
Where do you get your injury?
But I have alleged.
Okay, let us see your injury.
But that is two parts, my lord. Last matter is page 21 to 28. Lokman Ali. It's not the petitioner, but my lord,
Okay, considering the stage of investigation and period of detention. Allowed. To the satisfaction of
to the satisfaction, my lord, it's okay, yes. Any amount of members,
to the satisfaction of whom?
my lord, arresting authority, I will.
What you say, bail application, can arresting authority grant you bail?
No, no, my lord, sorry, my lord, CGN, my lord,
That's it, that you should say. Procedure Hachimi man. Next is 26.
26, my lord. After this case, my lord,
Same affair.
Same affair.
Same affair. What, who has been specifically implicated, madam? And others? Huh? You go through these petitioners, see the order dated 78. Order dated 78, these are the petitioners. All are given interim.
Only three petitioners are given in matter.
Who are they?
My lord, petitioner number, my lord,
You give a note, where are the, and phlegma, give, remove this phlegma. And because injury repeat we have seen, there was a marpit by both the parties.
my lord.
Injury is there, but that will not give the privilege if they are directly involved. Please see who are directly involved, those cases will be rejected. And if there are no specific implications is there, they will be allowed. Yes. Come after some time, go through this and this petition. 25, disposed of.
I will oblige you.
Yes, 26, go through it.
I think 27.
I don't know what that's my lord. Information he got, some wrong information, but taken to hospital, again he was got to jail. So I took the point, check up your thing, and your.
Okay, so therefore, the jail authority shall give a status report regarding the present health condition of the petition. And also indicate whether he requires further treatment in a better hospital. I will order to. Yes, next.
Now, this is a case file of was arrested on 10/7/23. And the FIR might be 1.
Okay, I'll tell him, no problem. Who are you?
Everybody was found here and graduate that one. We have this case file.
Rahim Badsha,
And for him,
Rahim and Karim.
name is very nice, father. The people also, I think, madam, the RDA, there was a case against them. There was, my lord, the FIR against this person, against these two persons. The fight still going on for last time. This FIR itself sold, madam, the day for him.
The Gambura said that there was a quarrel between husband of the informant and the accused number 1 and 2. And thereafter body was found in the railway track. So we'll require a sketch diary.
page 43, page 94. Therefore, in page 15, just 15, they have mentioned the idea. Only because of that, my brother. He mentioned that on last 14 to 20 hours, what it takes.
Where page?
Page 15. FIR last part.
Yes.
He mentioned that from last 14 to 23, the approximately persons and the people of the dynasty of my brother Rasmotari and the Kolari got their right. Regarding the said incident, suppose cases from 31 to 23 were registered and many active for the in this case, we also names, but police file FIR against the.
But that will not automatically say that will not. This is not a case at, yes, they are,
Last time was.
how many days you have?
3 days.
53 days, yes, at least 65 days they should go. There are some standards,
At least once, it should be there.
yes. 60 to 65. Yes, you have the case,
7 or 8, so.
as Mr. Das says.
60 to 65 months, that is my lot beneficial to the accused now. 60 days.
On 13th.
13th.
13 to
13th will be, yes, Das.
I can give shortly, but if city doesn't come.
Last time also message already come from the office.
No, yes, I have to send the message.
So it will come. I told message.
Okay, 13th. 13th will, even if not cities, they remind us.
13 it will be about 70 days.
Okay, 5 days more.
Some 3 4 days are there.
Yes, Das. Senior advocate is requesting 5 days prior.
Holidays are there.
Holidays are there.
Only 7 it will be there.
Okay, give a date, we'll see. After 60 days, give a date.
Seven is the 60, 8 or 9 months. After 60 days.
You gave 13,
Yes.
then according to her also TK আছে, because she is maintaining the rose diary.
But here in this book, I think what is the.
Okay, 10.
2 or 3 days, I will not-
10. Huh? 11,
This Sunday.
11, yes.
28.
At least you got something. Yes. Mr. Das, the time we are taking to dispose of bills are lesser than the time taken in fixing a date. Time disposing of bill applications are lesser than deciding what should be the date. Yes, you purchase the SIM.
By purchasing the same,
Hmm.
or in my allegation, the SIM was, by purchasing the SIM, the SIM was of the prime accused. He was I purchased the SIM from him, but he was a special because he has the right to sell the SIM.
Where is the petition submitted by the Vice President?
Forwarding is not the ground, the prime accused person and wants to, was using the suspected Vodafone, he was a retailer shop. I used the SIM of the retailer's owner who told me a SIM and I purchased it. To be of mine, I paid the amount, it's only one SIM item. So even I am the victim in this way. And the end of it. That is it.
Let him go.
Very serious.
Serious. Yes, whatever.
All on the basis of fake documents, SIMs are being sold and cyber crime sold.
No, I am not the person. In the FIR, I purchased only once. My allegation is only,
So how SIM can be purchased like that?
only one.
Kindly come to page 2.
Page 13, grounds of arrest, the accused person, Dr. Kumar Dekha is the prime accused person. And
Mr.
Mohammed Kumar Nath is the accused person who are using the suspected Goravan SIM card on behalf of Dr. Kumar Nath.
I know both, also Kumar and this petitioner. He has also, according to his own statement, he has also retired as him.
Yes, I was not aware of that, it was a retailer SIM. Only one SIM was recovered from my SIM. Then this is the recovery.
And as many as 13 dealers of setting identified till now. Who are selling fake SIM cards. And SIM cards only this is fake.
One SIM card was recovered from my side of this, only one SIM card.
His SIM card is.
If I am involved in this scam, lots of SIM cards to get recovered from that, nothing. In the statement also, I have stated specifically that I am a bona fide purchaser of a SIM. They are not a provider. Being a consumer and apply for a SIM card and you are using a SIM card supplied by Sri Dr. Kumar Dekha to be your own. And the SIM card was inserted by Dr. Kumar Dekha in his mobile while purchasing the fake SIM card. The petitioner taxes that he has been made.
Who is the owner of this M Communication? M Communication was the point of sale of Vodafone. Now they could learn that SIMs were sold with the fake document by this M Communication. Now therefore they have discontinued and the SIMs activated on the basis of false documents has already been deactivated. Actually, FIR is page 12. That is the allegation by blacklisted point of sale by removing the activation right.
There are some 30 POS have been identified.
Okay, all did that. How is he is also POS.
He has also retailer. He is also retailer. According to he knows that.
If he is a POS, then it's difficult.
His SIM card has been he is active, his SIM card, so many SIM cards are activated and those are being analyzed by, I think this meeting.
You need them or
For the time being, at least, investigation are done. And already, analysis are
What will happen, Lord? I'm only one SIM is being recovered from myself. If not, in many.
recovering one SIM is not important. Important is that this point of sales are selling SIM cards on the basis of fake documents.
But I'm not the point of sale. If I'm not the
According to them, the case there is says you have point of sale. So as that.
My statement is there. No, nothing of it. He is saying that statement is
So as okay, let us read this.
He is saying that my statement is there. Statement is not his statement. Statement law. There will not I have never been at point of sale at any point of time. This is my statement is a lot. Second or third line. It is a 151 statement. Where is the prosecuting agency cannot at any point of time prove that I am a point of sale at any point of time. I am bona fide purchaser who purchased from the Dr. Kumar Dekha with the prime issue, who was a point of sale. And he inserted the thing in only.
What are the offenses registered? What are the offenses registered?
409 also. Which is 90 days.
Put your name. At the start, 409 is not applicable. Total intervention of family is fully cooperative. Investigate when required. Only one SIM card is covered, and I'm not a point of sale. That is not common. This I'm point of sale is total. My statement is recorded by the police. I will give
Now with that SIM, that is a retailer SIM. That is not a normal SIM. It is a retailer SIM. Through that, you can activate SIMs.
That is what I am opposing.
No, it's not, my SIM is.
Yes, your SIM is a retailer SIM. And you give it to, you give it, you got, you,
I have never.
and you gave it to Nazimuddin.
That's there.
Nazimuddin created different SIMs, and through those SIMs, many cyber crimes are done, because if it's a retailer SIM, that cannot be identified from where it is done. That is having advantage. Therefore, all these retail, yes, you gave it to Nazimuddin.
It is not that, I have never given it. It's just given by order.
We are not doing any trial. We are in a
So there-
bail. Whether these statements are reliable or not, that will be the question of trial.
That's true, Lordship. Then also, Lordship, purchasing things like the one, and what will happen, Lordship? The day we need something, only purchasing, already purchasing. things.
Now, whether this Nazimuddin is arrested,
Yes. He was arrested. First he was arrested. Thereafter this people came.
Nazimuddin was arrested.
On any counter point, I don't, Lordship, saying when it comes to the interrogation, what will happen, Lordship? I will cooperate with the, even I am, even I'm ready to cooperate at any point. Will stick condition may my force.
Okay, more or less his part is over. His statement and other, and there are further investigation relating to some other POS, not to him. His part, Harsha and Nazimuddin, that part is over.
His SIM card is safe, because that has to be analyzed. From his SIM, how many?
But for that, will you require him? I think after looking at the CD, his custody is detention is not necessary. If you require, he will appear before you.
Only the middle of my getting very important.
Oh.
Because cyber crime is.
Yes, very
galloping
difficult.
rate.
He,
Some cyber crime is increasing in a galloping rate.
and that also relates to the staff from our district. It's the source now.
Yeah.
Earlier it was Jharkhand, something like that.
My objection may be.
Okay. Okay. The learned additional public prosecutor while seriously objecting the bail application, submits that this is a racket of cyber crime and petitioner was one of the part of such racket. He being a retailer / point of sale of Vodafone, he used the retailer SIM and gave it to some other accused who in turn used the same for doing cyber crimes and offenses.
And that's in a number of SIM card has been.
And through the SIM belonging to the petitioner, retailer SIM belonging to the petitioner has been used to activate many other SIM cards for the purpose of commission of cyber crime. What is the maximum period? 60 days, 90 days. How many days? Okay. The No, we are not giving for the time being. The IO's note also reflects that in the meantime, certain new information has been gathered and those were incorporated as the IO's note reflects that during the investigation, similar offenses were similar offenses committed by other persons has also been identified and some complaint received has been directed to be treated as supplementary FIR to the present case. Full stop. Considering the stage of investigation, this court is of the view that court is of the view that it will not be releasing the petitioner on bail at this stage shall be against the interest of the investigation. Accordingly, the present application stands rejected at this stage.
29,
2 days behind the bankruptcy. And the FIR was brought after 5 months of the analysis. 5 months of the analysis, it's still not, and the victims are already recovered. I mean, very lordship. Can I go to the FIR now?
Already search it filed.
Something, at least some observation. Already 42 days.
Serious offense.
But can I go to the FIR?
Yes, you read. No, if you want to make an observation, okay, read the FIR.
On 16 to 2026.
Mm,
And FIR was logged 21/7/2026.
okay. Mm,
The accused person is my daughter, Sheikh Rashmi Sunari, age about 50 years to Rajasthan, by receiving and enticing her when I was not at home.
mm,
When my wife told me about it over the phone, I called the accused and discussed with her and asked her to bring my daughter back. And on thinking about the future image of my daughter, I became more taken. After coming back from work, they discussed the matter with the accused and the accused accused me. They have still told her and bring my daughter within 10 days. Therefore, I agreed on 21/07/2023 when I came to know that she was a CWC on Friday. I went there to see her. Then I called the festival that daughter and was by the accused. 5 months she has been living in Rajasthan.
we know how this 50, so you want some observation? Let us make this observation. That the police even shall now proceed with further investigation to trace out the racket. This 15 years girl was taken to Rajasthan, who are being put into sex racket.
No. That is not.
So let us have the observation. You want an observation? This is the observation of this court. Let us have this observation. Yes, Daddy. Sarsit has already repeated. Sarsit has already filed. Accordingly closed.
timing item 26.
Tell me who are involved, who was directly implicated. Because injuries are there. No doubt about this. We have given them serious injuries, but because taking note of cross FIR and Marpit, we have given them. Now, who are the specifically? Riazul Islam. Then Riazul Islam. Petitioner number Manna fees 15. Munna Fali. Okay. And
3, 4, 5.
petitioner number 3, 4, 5. 1, 1, 3, 4, 5. 9, 10, 12, and 15 are granted, others rejected. Don't go any further.
Outside injury, my lord, outside, one number is seriously injured, my lord. Additional number of. And I need to pay my lord, the,
Vulnerable areas they got from the bed.
my lord, at least my lord, the.
Death is the injury is there. That's
Yes, it is now.
don't argue further. Except 1, 3, 4, 5, 9, 10, 12, and 15. Huh? Others are granted. Yes.
My lord, secondary injury may be granted from severe injury.
If they will give you proper treatment in hospital. Come back to us. Dispose. CD return. Order to Sava, most of red mark Manchurisu. Rejected below red mark.
Bail hearing, I think 30 and 31.
30 and 31 case there is not received, my lord.
Any interim? When?
12-10.
12, 10. Interim to continue.
33. Yeah.
50 circuit submit.
Any interim?
Interim.
Interim is, yes. It's a sessions tribal or magistrate tribal? Tribal by whom? Magistrate. Till appearance on someone, interim or.
Other because of the
It is submitted, okay, no, not necessary, person, CS being CS number
CS number 96 of the 23.
96/23. Dated, okay, 96, accordingly, the Learned Council for the petitioner submits that this bill application may be closed. Where is allowed, the petition stands closed.
I think 34.
Yes, where is the affair? Hmm? What is your name? How many petitioners? Badruz Islam, Barhuya. You are a little bit weak in English. So where is the vernacular? I have not been able to understand.
Page 13.
Yes, okay. Yes, what is the injury report?
Yes, and the injury report is not available here, but my lord, here one case he admitted in PMC incident occurred on April 23. He admitted a outdoor patient in PMC on April 23. And my lord, external deformity absent, there is not specifically mentioned whether simple injury.
But according to the informant, আমার স্বামীকে উপর্য পরিচ্ছেদ মারিলে আমার স্বামী বাম হাত ও কাঁধে গুরুতর জখম হয় আর আমার স্বামী হালা চিৎকার করে। Then it was said that সাক্ষীগণের সহযোগিতায় আমার স্বামী জখমীকে নিয়ে হাইলাকান্দি এসকে সিভিল হাসপাতালে আসি এবং আশঙ্কাজনক দেখিয়া উন্নত চিকিৎসার জন্য স্বামীকে শিলচর মেডিকেল কলেজে পাঠায়।
Only on 8/5/23 as per that my lord claim.
Hmm.
8/5/23 as my lord, 2 p.m. he admitted in Silchar Medical College. There is nothing mentioned when he is discharged. For me, he admitted on 8/5/23 on the same day.
And what is the medical,
Injury report is not over. Then I will have to report for the
how many days behind?
baby. Last order that kind.
Oh, this is not a case for every. Last order we have seen.
And injured my indictment is also available. He said that this is the person who is different.
And any other villagers who, according to the informant, villagers saved him.
Because they directly not said that this person. So at that point of time, they came after hearing my given time and they are taken to the. What report is every time of admission in the system. There is no information, regarding text, alphabet, photograph is there in the, this process in one hand.
Injuries are there. Injuries are there. Tendon injury in left forearm. Your investigation officer really. They will annex the 90 rupees bill for X-ray, but X-ray report they will not give. Huh? Who is this investigating officer? He will annex 90 rupees for service of X-ray, and the report is not there. Yes. Fracture. Rejected. No injury report is required. There was a, maybe they will not give bail to him also. It's a privilege. 430 it is a privilege. A person will repair his house. He will come and beat him up. And he beat him up, and he admittedly he was brought with that history of assault to the Silchar Medical College. Doctor had seen the injury. There was a direction for this X-ray. Though the investigation officer has not submitted the report of X-ray, but a photograph says full fracture and it's a plaster, rejected. Not a case for privilege of grant of privilege of PRS bill. Huh?
35.
Yes. Yes, whatever.
Madam, in this case, madam, after this case, fixed on 12/9. In this case, madam, cause of death, madam, also PM report received. Madam, opinion regarding the cause of death is kept pending till receipt of chemical analysis report from DFS director. So,
When the other matter is fixed,
on 12/9.
okay. List this matter on 12th of September, along with
AB 1767
AB 1767 23. Interim order passed earlier shall continue. Continue. And on the said date 6, the FSL report be produced. What is this? Why this matter is listed? What order should we pass? Admission, you have already appeared. None appears for the petitioner on call. However, Mr. SK Gupta, Learned Council submits that he has entered appearance on behalf. Oh, you are there.
On behalf of NJ Das.
NJ. You are Mr.
And yes, and
M. Hassan. Heard Mr. M. Hassan appearing on behalf of the Learned Council for the petitioner. Also Mr. MK SK Gupta, Learned Council for the respondent. As the matter is ready as regards service, list it in the admission column on after 2 weeks, on a day 2 weeks later. In view of official date 24/8/2023, await service report and be listed after 2 weeks.
140.
This is an application for condonation of delay of 40 days in filing criminal revision petition, connected criminal revision petition. Mr. Borthakur, you are not a party, Mr. Borthakur. Mr. Bhattakur accepts notice on behalf of respondent number 2, full stop, issue notice, issue notice. Issue notice returnable after 6 weeks. Mr. Bhattakur accepts notice on behalf of respondent number 2. No, লিখিব।
41,
Yes.
I had severe stomach pain, so I was taken to the civil hospital. So it is found that multiple ulcerative here, pancreas, study, and mother grade 3 liver response. So this report I did not get response. Right now I'm having protocol. Now the condition of the medicine not that even everything easy to fix now. You know, they had a speed effect in the college now. And one of six man of this physician also was one of the member now. The person was
Why this I is for what?
following those documents from the jail authorities because Mala is seriously involved and the mail application is for paid it is just for 8 months. He's already presented case Mala. You get to arrest him. He's a retired man.
Where is the affair?
FIR Mala, I will find the FIR at page 15 Mala. Page 15. If you respect adjectives from the constituency, my elder brother to pass on my account, and I was studying for life, except on of his residence, and when I saw him there, and with the help of family members, he rescued him. I took him to Vishwara College City of Peace, where during the treatment, the doctor declared my brother dead. Immediately, police was informed about the matter over the phone, and after that, the police arrived and took the dead body of my brother from the father to the city of police station. But on Tuesday at around 6 in the morning, inside the house of my brother found it, and he was in the stable and then the drawer of the Almara. The opposite letter was seen by my mother of the sister-in-law. She informed me about that. The opposite part found a time of after finished. That no one can be my family's letter for my dad. The three secretary member Himansu Bora of Senior Secondary School forced me to die home that the government gave him punishment. He was used to the body money of the society from me. In the end, Himansu Bora escaped from it and shifted all the blame on me. All the staff members called him guilty and further believed that we were guilty. The case in hand of the society written by Parthopati. The disease mine. Parthopati is the disease. Himansu Bora should be also pay. Both should pay half.
Bhattakur, why you need this man for a custody? Consider the bail application. Stands allowed.
If you
No order. Pura satisfaction of
CGM Vishwanath.
CGM Vishwanath Sariali. I Lekibo as in view of order passed in BA number 2926. No further order need be passed in the present application, and the present application stands closed.
If you
Yes. Okay, now the enforcement. We'll first take up those matters where 451, 457 is not involved, including Mr. Bora's case. Then we'll come back to you.
That is my 451 and 457 letter. I will take some other thing.
Just wait for some time. It's not the time to go home.
No, it's not for that matter.
Yes. Okay, give one by one. We are allowing Mr. Bora's application. Bhattakur, I am saying my intention.
That is
Almost all the applications we are allowing. In case of Bora's application, it was a finding of the magistrate or whatsoever that everything is there. However, this is investigation is going on. What is the purpose served? Court came to a finding that what do you call it? VAT is there, permission is there. Everything is a finding of a court. Let the vehicle go.
regarding that, yes, I have no doubt regarding other 5 cases.
We come one by one. So this is a basic idea. It's not that we have made up our mind. This is an idea. If you can,
Under 420 miles, well, if it's to
well, we keep to pass this order. Therefore, we'll pass this order except item number 12, because their petition was rejected in terms of in view that I don't have power under 451. And the appeal preferred by Mr. Goswami. We'll see that. And if PP is in which case?
Both together.
Yeah.
Together.
Oh,
But when came here, regarding the issue 450 and 450, the
Okay.
difference between what is the difference between
So,
450 and 450?
in apprehension that you may get attacked at the hands of Mr. Bora, he might get attacked.
My product, they have to say immediately granted. It's a caller, a double engine.
Double engine. Because
So
you,
my only one would be there, madam. Let him be there
Hmm.
as an American, that will serve the purpose, probably. Then the purpose will serve, but the objection I have raised on the last.
but how can he be a mega? He argued the case before.
Now,
the
it's
judge.
not- it's not-
He can appear, my lord. On behalf of PP, he can appear.
No, no, not on behalf of PP. He can appear, we will not go to those things in this case. It's not that we will not go sometimes, we will not go in this case. So we are calling one by one, except those 450 and meter. Mr. Bora, you'll be also there. Call serially and Mr. Bora will help us. Which are those cases where vehicle is pending, cattle is recovered, betel nut is there, well, let us see all those things. Mr. Bora will be here for something. Where is that? Where is our earlier order? I asked them to give me.
Motion.
Just give me a minute.
Regarding my.
Just a minute, just a minute. Hey, hello. 30% order to be.
Is also rejected in view of, because of 451.
If 451, then it will be a separate. We will hear Mr. Goswami and public prosecutor.
Second number 13.
Yes. And also Mr. Bora. Mr. Bora will be amicus in this case.
Item 15.
Okay, item 15. What is
15, my lord, regarding my lord, one, vehicle Tata, my lord.
Hmm.
So in this case, my lord, I have to receive the report, today, yesterday, but report I have not yet received.
What was the offense? How it was?
And in this case, also, my lord, case 39, last question, I will take another section.
Who is the for the petitioner?
Section number 15.
Among
Among conduct.
Okay. The present application is filed. This is the problem. The police might have given him the Jimma. Will pass an order. Petitioner is not here. Otherwise, we are willing to allow this. Present application is filed under section 482 of the Code of Criminal Procedure, assailing an order that or assailing orders dated 16/11/2022 and 5/1/2022 passed by the learned special judge Gwalpara in special NDPS case number 29/2022 in connection with Gwalpara PS case number 139/2022 corresponding to GR case number 805/2022 under section 21 within bracket small b /29 NDPS Act, whereby the Jimma of a vehicle allegedly from which the alleged contraband was recovered. Full stop. LS contraband was recovered. From the impugned order, it is seen that the learned court below has come to a conclusion that the petitioner is the registered owner. However, for the reason that the petitioner has failed to explain the reason how the contraband, LS contraband, was found in the vehicle inside the seat of the driver. Accordingly, the Jimma petition was rejected. The Honorable Apex Court in the case of Sundarbhai Ambala Desai versus State of Gujarat, reported in 2002 10 SCC 282, while dealing with the power of magistrate under section 451 and 457 CRPC regarding disposal of seized material, has laid down the following proposition of law. 1, 2, 3 already that is dictated. Now coming to the present case, whether the registered owner is instrumental or a part of the offense as alleged is to be determined during the trial. As discussed here in above, the Honorable Apex Court in Sundarbhai Ambala Desai opined that the power under section 451 CRPC is required to be exercised expeditiously and judiciously, and it is clear from the aforesaid judgment that the object of such determination is that owner of the article should not suffer because of its remaining unused or by its misappropriation. In view of the aforesaid dictum, this court is of the considered opinion that grant of Jimma of the vehicle in question will in no way hamper the trial / investigation in the case, inasmuch as discussed, as laid down in Sundarbhai Ambala within bracket Supra, certain conditions can be put to protect the interest of the trial as well as investigation. Accordingly, the present application stands allowed with the following condition. Okay, dispose of item number 15. We'll write something that you have objected, this will come later. Okay. 16, same, dispose of. We'll see just the order why it was rejected. Investigation is still pending. Rejection of. Okay, I'll give this order separately, one paragraph. After this order is complete, then thereafter I'll add case wise a paragraph.
17.
Yes, what is this? Yeah. Here is no time being. Today there is no time being. Please this method. Report is there. Motion, okay. This is an application under Spencer Sikhi Jimma. Mr. Bothakot shall obtain instruction from the investigating officer whether the further custody of the vehicle or what vehicle is required or not. List accordingly on in the motion itself. 19.
Okay.
Item 12.
Bakila ho gel. 12 is star mark 451.
Yes.
Rejection on the ground of 451. It will after some time. After 50, after some time.
13.
13 also same. And what would tell us who are the which are one are the gym. 13 also 451.
Is not for the yes,
Rejected on 451. Okay. No. What would give us the cases? Which are the cases called that?
Item number 14, 12.
12 gone. 13 gone. We'll hear these two stalwarts.
15, 16, 17, then 21, 20,
20.
item number 20, I have received the report.
20. These are the on the same case. Jimma. No. 15 gone long way.
This is the report regarding item number
20.
20.
Yes, give the 20. We are taking only the Jimma cases now. Maybe admission, maybe passing. Except few cases which involves a question of law.
This secret chamber was
This vehicle cannot be released. This is a special purpose vehicle. Not that somebody has taken loan, somebody is taking a cattle, it was said, somebody is bringing medicines with license, is not that. So what? You have a special separate chamber to bring contraband. So you have already done that. This is, we are not to decide, you approach the trial court. This is an application under Yes. 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 Without entering into the subject matter, in exercise of under 482, this court is of the opinion that this is not a fit case where a Jimma can be granted in excess of the power under 482, more particularly in view of the report of the IO that a special chamber was created in the vehicle to carry contraband by hiding it. You want that, we'll direct that to appear before, because the report also said that you are not appearing before the, you go there. We are providing you file and application, the IO will consider, they will arrest you. You want that? Want that observation that you will go to the police station? The specific allegation is there. To give you Zimma, you need bail also in this case. Do you understand that? So what to do? Reject or withdraw? Accordingly, this court is of the view that this is not a fit case to exercise its power under section 482 to direct Zimma of the vehicle. Okay. Petition stands dismissed. The report submitted by IO is kept on record. It is, however, while parting with the record, it is provided that the petitioner may file appropriate application at appropriate stage before the learned. Okay, not in, change the word, not 48, in exercise of its revisional power. Say that. Don't say 482, in exercise of its revisional power.
Next one.
Rejected. Next, Bota or which one?
Next, 21.
21.
Item 21.
Yes, 451.
Yes, 21 is there.
Rejected on 451. Okay, keeps person sometime.
Then my state effects 43, 45, 46.
So others are over. Yes. Now let us start this. Where is Mr. Goswami?
And otherwise, 3 only left, admission methods left.
Only 3 admission methods left. So after completing that, we will come back. Okay. 2 admission methods are there. Mr. Bora, you relied on the judgment on that that judgment somehow I have misplaced.
I'll provide it.
Somehow I have misplaced. Let us give
22.
a try. Okay.
For admission, 22.
Mr. Bothakur was here. Any urgency?
I have no idea. madam.
There is already a stay.
It is there.
There is a stay already. No, it shall not be examined PW4.
Yes.
So we hear it after coming from the vacation. Okay. Bothakur. Immediately on reopening. Give a date, Musumi, in we'll hear this matter.
On 8,
On
8.
8 may not be possible.
Then 13.
13. 15.
15.
Okay. As agreed to by the learned council for the parties, leave this matter on 15th of this 15th of September 2023.
For Koshman,
Interim order pass.
for Koshman, item 42.
Yes.
You must work on the IO. I think as like here
I think in Sundarbhai Ambala, there is a paragraph somewhere which says that cash money should not be freezed in the interest of the economy of the state. Cash should be deposited by a fixed deposit in any nationalized bank. And is it that case?
Regarding those money were not calculated. After recovering, in the trunk money.
Trunk. So instead of keeping it a trunk, it should be a photograph of the or something like a photograph of the some notes should be taken. Then it should be signed by both the parties, and it should go on circulation. That is the law, is that it?
Well, I have also stated in his report that there is no difficulty.
Okay.
It may be directed to and whatever may be required to be taken.
Avni Sabo. Criminal this hard. This is an application under section 482 of the CRPC for quashing of impugn order dated 19/10/2020 passed by the learned judicial magistrate first class Kamrup Metro in whereby where is the order? Page huh? 30. Okay. Whereby the whereby the learned court declined to pass any order of Jimma of seized cash amounting to rupees 80 lakhs for the reason that the investigating authority has already given the Jimma of the aforesaid cash amount to the bank itself during the period of investigation. The learned counsel for the bank submits that the amount of rupees 80 lakhs is kept in a trunk under the custody of the bank. However, the said cash amount is not under circulation, and therefore they may be allowed to circulate the aforesaid amount inasmuch as admittedly the said amount cash amount belongs to the bank and belongs to the bank. Full stop. This so far relating to the Jimma or freezing of money, it is law is by now well settled that money should not be freezed during the investigation or trial in the interest of economy of the state, and cash seized should be deposited by way of FDR in any national in any nationalized bank. In the case in hand, the FIR was lodged by the bank, petitioner bank, with an allegation that while transporting the trunk consisting of having 80 lakhs rupees, an attempt was made to snatch away the two trunks. Two trunks consisting of 40 lakhs each was at 40 lakhs and 80 lakhs. Now you want the 80 lakhs. What about the 40?
40 lakh is not stolen, so we are not,
While transporting two trunks having cash amount of 80 lakhs and 40 lakhs, an attempt was made to snatch away the same, and the trunk having 40 lakhs was snatched away. However, due to intervention of the local people and the guard of the bank, the other trunk was could not be snatched away by the miscreants. Full stop. In the aforesaid backdrop and the settled proposition of law, this court is of the view that the money be allowed, the money amounting to rupees 80 lakhs be allowed to be kept as fixed deposit. You have a fixed deposit, or you want to circulate? Okay, money be allowed to be circulated to the petitioner bank with the following conditions. Okay, we'll give conditions that you will. You are informant. Okay, okay. You which bank? IndusInd Bank. Also heard the respondent number 2, IndusInd Bank, as the excess amount of rupees. Okay, and in the also heard Mr. D. Borua, IndusInd Bank. We'll give those conditions. You have this and circulated, disposed of.
43,
But all these orders will come after 7. If possible, we'll try today. Ah,
40 is another along with others, which will dispose of by the.
yes, Mr. Bora, come forward.
Under what circumstances whether matters were referred to?
Now tell me one thing. What is the distinguishable factor between 451 and 457?
451 and 457 is the exercise. Two distinguishable factors. Firstly, during trial and inquiry, and secondly, in respect of 451.
What is the common between 451 and 457?
Trial and inquiry.
So according to you, common factor is that the power upon the magistrate is vested during the trial and inquiry. This is your argument. This is the common.
And
But under two situations.
one is when the articles are produced is 451,
Mm.
when the articles are not produced is
456.
And during investigation, well, it is by the police
Under 102. Okay, under 102. Now, what is the finding of the division bench on 451? Division bench concluded that there is a difference between inquiry and trial and investigation. So since there is a difference between investigation, inquiry and trial, during investigation
cannot be granted.
cannot be granted under 451.
But
If that is the logic, then
That
that
would be the
cannot
same
be
logic for-
cannot be granted in respect of 457
So
also.
that be the same logic for both.
So therefore, if it can be granted under 457, then it can be granted under 451 also.
That was not dealt with by him.
What was the findings of the division bench so far relating to 451 to conclude in the penultimate paragraph that 451 is not applicable? Kindly show us the decision, because before us we are in a situation where Sundar Bhai quoted 451, 457 and says that magistrate should pass an order as early as possible. Now, as early as possible will mean what? And preferably within 30 days.
Coming to the division bench.
Kindly show me the discussion of the division bench on 451.
Yes.
We could, there is a decision that trial and there is a difference between trial, inquiry and investigation. No quarrel on that.
And the word investigation is not there in 451 and 457.
Seven.
If
So
we-
therefore,
if we accept that these powers can be exercised in investigation stage, that thereby it will mean that my lords are inserting the word investigation. in the-
okay. My lords are not
Because my lords are
investigating.
on the phone to do
The
something.
my lords had already,
No. In fact, my lord will kindly see, with greatest respect, my lord, Sundar Bhai Ambala, my lord, honestly, that judgment itself is a judgment passing outside. Because that was, this was not an issue frame
Hmm.
before the Honorable Supreme Court, where what stage this custody can be done.
now Sundar Bhai Ambala was decided on the basis of an earlier judgment by authored by, I think, that what was the context in that 457?
Yes.
If you read that judgment, what was dealt with 457, that is not a, that was not even a ratio.
Actually, even if we consider that to be a ratio, that ratio is not applicable in this case because the ratio pertains to the fact of that case.
Hmm.
And in that case, there is no issue frame regarding the state in which 451 and 457.
So the division bench judgment relying on the earlier judgment so far relating to 457 having power
Because in that case.
in from that judgment, if that judgment says 457, same ratio will be applicable in 451.
Judgment, my lord, Honorable Supreme Court, rather, my lord, with greatest respect, made a
So now
finding-
tell us, we'll record all this, that this is the confusion before a single judge.
Right.
We'll record everything.
Right.
That this was the findings in so and so, this is the ratio of so and so,
Right.
this is the ratio of so and so. This is, now we are a situation, except the language of trial, production and this, there is no difference between 451 and 457. So what this bench will do? Now, what is the alternative for this bench satisfy us on
If my
that?
lord is not accepting the judgment of the Honorable
No, I-
Division Bench,
No,
if
I-
I is in disagreement with the Division Bench judgment, my lord, only could left is to my lord refer it to the Honorable Supreme Court.
no, that cannot be. First thing is that it is a binding precedent.
My name. If it is a binding-
Only way out to disagree. I cannot say that I disagree. I will have to put a question that
why does it exist?
which road should I go?
Exactly.
This is the ratio, this is the ratio, this is the ratio. This is division bench, this has not been discussed. So what road should I go? I cannot say that the division bench is bad or good.
Because my lord, we kindly.
Then suppose that is the situation, what is the option left for a single bench?
And passes a different order,
Hmm.
then that of Division Bench.
Hmm.
But the courts below will be, my lord.
Confused. Yes,
Thoroughly confused. my lord.
Thoroughly
Judgment
confused.
is to be put.
we are,
So in
this,
that case, if my.
forget about the confusion of the lower courts. This court sitting singly after reading Ambala, Sundar Bhai, then the earlier judgment
Ram
of
Prakash Sharma.
Ram Prakash Sharma and division bench itself is confused. If the logic applied for 457, we go by the logic, then 451 will have to apply the logic. And if we go by the 451 logic, we will apply the same to the 457. So then what is the option for a single just address on that?
Because, my lord, option left is, my lord, to follow the Division Bench. Because these issues were raised before Division Bench.
Hmm.
Sundar Rai Ambala was discussed, Niveda property is discussed, Ram Prakash Sharma was discussed. Then rightly or wrongly, my lord, Division Bench has passed an order, which is binding.
No, this is binding.
In a case that Sundar Rai Ambala was not. placed.
No, this is a binding precedent. That there is no quarrel on that. But we go by the ratio.
Yes.
What is the ratio of the division bench?
Ratio is 451 cannot be exercised, 457 can.
No, that cannot be the ratio.
That's the ratio.
Ratio is that the magistrate shall have no power to exercise
Grant of custody.
grant of custody for the reason that it is not it can be exercised during trial and inquiry, and investigation is not a trial and inquiry. I think this is the ratio. If that is the ratio, how do I follow in case of 451 and how I differ in
Because
457?
457, there is separate ratio. 457 says the reset can exercise power if it is not produced. There is also a ratio for 457 also. Division bench has not only classic 451. In fact, in my respectful submission, my lord, division bench, my lord, ought to have passed the same ratio in respect of
Is
both
what-
the
That is what I am saying.
either in
that-
grant custody or don't conduct.
Therefore, ratio is, according to me, subject to what Mr. Bora says and what you and Mahan is also there, will hear you also. The issue is how it was structured, division bench. First issue was that, what is there any difference between trial, inquiry and investigation?
That was discussed by the.
This was discussed by division bench. So division bench comes to a conclusion that there is a difference between these three. Inquiry is something different, trial, investigation is something different. It was also decided that the power to grant Zimma during investigation is under section 102.
I fully agree with it.
If you agree with it, whatever we will not go to that. The power during investigation vested by the statute upon the investigating
There
authority.
is a reason behind it.
No, we have no quarrel on that. We agree.
My lord, kindly appreciate one thing. If these sections have a history, has a history. For example, 102 power, earlier police power was only to seize, not to grant custody. In 1973, it was inserted. After 40.
Okay, we are not quarreling on that.
In respect of magistrate power, my lord, there was no state indicated prior to 1973.
Yes.
Stages were indicated only in 1970. That itself means the part of investigation was consciously excluded by the way. Earlier it was not barred.
Okay. So we are coming to the first division bench ratio.
Right.
What is the ratio? That there is a difference between investigation, inquiry and trial. Investigation cannot be treated to be part of an inquiry or trial. Okay, so this is first conclusion. Second conclusion is that being the position, the power under 451 to exercise a power under 451, the condition precedent is it must be inquiry or trial. Okay. Now, fine, no quarrel on that. 451, we agree with that view. We go by your argument. Now, in the earlier judgment, what was the judgment? Prior to Sundar Bhai, Ram Prasad sir.
Supreme Court allowed custody during investigation in court. That's why division bench could not.
Was it a ratio then?
It was not a ratio.
If it was not a
It was a
ratio,
passing comment in that given.
So if it was a-
Supreme Court.
if it was a passing comment, then the division bench will have to see that that is not a ratio.
In that
If
case-
it was a ratio, that no investigation, because that is subsequently supported by Sundar Bhai. So if that being the position, we will have to say that this is the situation. So we have not been able to decide. Let it go to the Honorable Chief Justice
That's the
and
proper-
have a larger bench or
That's the
some
proper
and
procedure.
give a
That
big.
situation, my lord, I will also be allowed to, my lord, make submission that 457 also is at same footing with 451. That was to that extent state is agreement. Though we have not filed any appeal. To that extent, our argument was same ratio for 451 and 457. Because as my lord has said, if 451.
It's a paradox. The judgment is a paradox. So it's subject to due respect to that, because principle should be either this way or that way.
That's
Cannot
why,
be
my
both.
lord, that's
That
why-
451 will during trial you cannot exercise. 457 you can exercise. That cannot be.
That's why-
And you can exercise because of the judgment in Ram Prasad. Ram Prasad said 457. If Ram Prasad said 457, both the sections except that production and non-production, they are in equal fitting, part perimeter area.
That's why I'm saying if my lord is, my lord, traveling through the judgment, my lord, and my lord comes to a conclusion, that conclusion can be either side. It can be.
Either side.
State also.
Yes.
Don't exercise.
No, I am not saying. If we go by that, this can be that, no. The same ratio shall be applicable in case of 457.
Try to persuade your lordship to apply the same ratio in respect of 457 also.
No, you cannot persuade. We'll have to say that this is the paradoxical situation.
Agree.
So let it go to the,
And that's the proper perspective.
we cannot say which was right, which is wrong. Now,
Because
Bora
law
will,
of percolation-
Bora will say us something more.
My lord, we kindly accuse one thing, law of par incurrence, my lord, is not such a flexible law that
No,
every
no.
court will disagree.
No, it's not a par incurrium, but Bora has gone further ahead.
Because there will be, my lord, uncertainty in.
No, no, par incurrium, I passed the judgment relying on a apex court judgment. Bora is now saying, yes, so far relating to par incurrium, the judgment rendered by me is correct. But the same judgment on the basis of which I dealt with the issue of par incurrium further goes to some other aspect where this court can pass. Now that is the issue where we'll think over whether we can do that.
For that, matter, I would like to submit some judgment on par incurrence.
It is, we cannot go, you need not argue. We are saying that we cannot say this judgment to be par incurrium. This is not having, I don't have that thing because everything is discussed. I cannot say par incurrium. But other argument, Mr. Bora, then will reply.
If my lord is referring it to larger bench, then I have no some. Or else.
No, not referring. These are the options before us. Because this court is little bit confused, which side to go. Because
That's why I-
principle laid down, if we apply the principle laid down so far relating to 451, the same is to be applied to 457. If we rely on the ratio laid down 457, we'll have to apply the 451. And admittedly, there is no specific discussion on 451.
If there is there,
That if you can show that this how 451 was dealt with.
my lord, may kindly take the visual record.
Yes.
First, my lord, paragraph 18. My lord, the provisions of CRPC under section 2. Then. That was quoted, my lord, what is investing.
No, I am having this copy,
Same copy, my lord.
same copy,
Page 13, paragraph 18.
page 13.
Paragraph 18. For adjudication, the issue at hand, the definition of the words inquiry and investigation as provided in section 2A. 2G are reproduced below. These are reproduced. Then what is investigation is also my lord recorded.
Mm.
Then my lord, paragraph 21.
Mm.
In case of Hardeep Singh, the apex court has held that the stage of inquiry commences insofar as the court is concerned with the filing of the charge sheet and the consideration of the materials collected by the prosecution. That is mentioned in the charge sheet for the purpose of trying the accused, which has to be understood in terms of section 2G CRPC, which defines as an inquiry as every inquiry other than a trial conducted by this court under this court by a magistrate or court. Then my lord, these two judgments are relied.
Mm.
Then my lord, paragraph 24, section 102. Now coming as to the question as to whether a criminal court can release custody of seized property during investigation
Mm.
under section 451 and 457 CRPC, or would have to see the provisions of 102, 451 to 457. And the judgments passed by the Supreme Court and various high courts. Then my lord, 102 quoted.
Mm.
Next 451 quoted.
Mm.
457 also reported.
Mm.
Now paragraph 25.
Mm.
On reading the various judgments enumerated in the foregoing paragraph and the provisions of chapter 34 of the Code of Criminal Procedure, we are of the view that the court can make an order for proper custody of the seized property under section 451 CRPC only after a charge sheet is filed. Section 452 CRPC is to be applied for disposal of property only at the conclusion of a trial and inquiry or trial. Section 459 CRPC on the other hand allows for the court to sell the seized property if the person entitled to possession of the property is unknown or absent and the property is subject to specie and natural decay, or that the sale would be for benefit of honor or the value of the property is less than rupees 500.
Hmm.
In case of Directorate of Intelligence versus so and so, the Delhi High Court held that the applicability of section 451 for the applicability of section 451 an inquiry or trial has essentially to be in progress.
Hmm.
In the case of Directorate of Revenue, Meghalaya High Court held that in the absence of a trial or inquiry under section 451, 457, magistrate could not have released the vehicles to the owner of the vehicle. These are the judgments passed by honorable single judges before the matter was referred to larger bench. These were in our favor, custody cannot be granted. Then, my Lord Justice R. Fukan, my Lord, disagreed because of the earlier judgment of the Court and referred it to the division bench. These all the single judges, my Lord, three different single judges, my Lord, held in our favor. The learned single judges of this court have held that during the investigation.
Which paragraph?
Paragraph 28.
In case of state of Assam versus.
State of Assam versus Nuruddin so and so.
Hmm.
Number 2, State of Assam versus so and so. Number 3, Rafiqul Islam versus State of Assam. The learned single judges of this court have held that during the investigation stage, the power to give custody of the seized property under section 451 could not be exercised by criminal court. Nothing was stated in the above three decisions with regard to whether the criminal court could have given custody of seized property during the investigation stage under section 457. Those judgments were confined to 451 only.
Hmm.
However, in the case of Sunil Gogoi, that was the earlier judgment. Another single bench of this court has held that the criminal court has the power to pass an order of interim custody to the rightful owner either under section 451 CRPC, pending trial of the case, and under section 457 CRPC when the property is seized by the police and trial has yet not started. Thus, a reading of the judgment of King Sunil Gogoi Supra implies that a criminal court can give custody of the seized property under 457 prior to the start of trial, that is, at the inquiry stage and investigation. In the case of Gopur Bhai so and so, the Bombay High Court has held the provision of section 457, which are sufficiently wide to cover a case when magistrate is called upon to pass an order for disposal of custody of the property during investigation stage. Then, my Lord, these two judgments, M.S. Jaggi, Ajay Singh, they were relied upon for 457. Now, paragraph 31, my Lord. In the case of Niveda Properties Private Limited versus so and so recorded in so and so, the issue that was to be decided by the apex court whether the expression any property used in subsection 1 of section 102 would include movable property and consequently whether a police officer investigating a criminal case could take custody of any seize and seize any movable property which may be found under circumstances which create suspicion of commission of an offence. Of any offence. The apex court on considering the above issue with conjunction with chapter 34 of the Code of CRPC, Code of Criminal Procedure, which relates to disposal of property under 451 to 459, held that section 451, 452 to 456 does not refer to any seized property under section 102. It held that the power of the criminal code under section 451, 452, 456 is not restricted to property seized by the police officer under 102 of the code. That is, it has the jurisdiction to give orders pertaining to immovable property also. However, section 457 CRPC applies to property which has been seized by the police officer under section 102 of the code, but not produced during inquiry and trial. The apex court thereafter held that the power of the criminal code under section 451.
No, Nevada was issue was something different. Nevada was whether immovable house of immovable property can be seized.
These are matter discussed and distinct in Nevada matter. Anyway, madam.
Hmm.
Next page 21, madam, last paragraph.
Hmm.
On considering the decision of the apex court in Nevada Properties Private Limited,
Where?
page 21 down below, madam, last paragraph.
Just a minute.
On considering the decision of the apex court in Nevada Properties, we are of the view that the apex court has not made any interpretation or laid down any law with regard to whether section 457 could be applicable at the stage of investigation. Accordingly, decision made in the above case, in our view, is not applicable to the issue to be decided herein. In the case of Ambika Roy, division bench of the Calcutta High Court held that words, any such property is not produced before a criminal court during inquiry or trial appearing section 457 merely referred to the stage of investigation and not the stage of inquiry or trial. As such, once the factum of seizure of a property has been reported to the court under the provisions of section 457, the criminal court could give custody of the seized property at the investigation stage under section 457. The Calcutta High Court also held that if the property was produced in court during the inquiry.
No, these are the five, what, according to what are the ratios? What is the finding of the court?
Yes.
Division bench. That 451, why 451 cannot be granted? I want that paragraph.
And why my lord 457 was
No.
distinguished?
That 457, there are reasons. But we want to see where is the findings that 451 can,
Yes.
finding is,
I'll
we have-
just one paragraph. before
we
that.
got the findings in
Yes.
last paragraph.
This
But
has-
the reasons, that the ratio, why?
Before that, only one paragraph, paragraph 41, 40.
Yes.
26,
Yes, 26.
26. In the case of Ram Prakash Sharma.
Just a minute, just a minute. 40, paragraph 40.
In the case of Ram Prakash Sharma Supra, the Supreme Court directed the criminal court to pass appropriate orders under section 457 CRPC for disposal of seized property during the investigation period. In the above case, the apex court has held that the court has power to dispose of property seized by the police, but not yet produced before the court under section 457 CRPC and before charge sheet has been submitted. This is why, my lord, the division bench, my lord, allowed custody.
Then how you will say that
Because that judgment was
specific on 457 may not be ratio? Then how will you deal with Sundar Bhai Ambala, where it was said that 451 magistrates should do?
Sundar Bhai Ambala, my lord, nowhere said that at the stage of investigation it should be granted, because that was not an issue. That was not an issue because honorable apex court, my lord, there was no issue from regarding the stated. And
Now,
Sundar Bhai
what is the finding of Ram Prakash? What is the ratio of Ram Prakash?
in my humble submission, there was no issue.
If no ratio, then
But division bench has applied, no.
what ratio apply? Tell us.
I will take a worship to the judgment.
One paragraph on that.
Exactly, only one.
One paragraph. I have read that.
Exactly.
So you'll have to show us that what is
That's
the.
why, my lord, if my lord is,
No, we'll
That
go
is my
each judgment. We'll say what is the ratio of Ram Prakash. We'll say we have not got any ratio.
that was
We'll record that Mr. Goswami also said that
Yes.
there is no ratio.
no, so that's why, my lord, the ratio 451 should have been applied by a division bench in 451.
And Mr. Bora will say that no. In view of Sundar Bhai, 450 and 457 different
This is-
object is the object. Supreme Court has said, what is the object? Why it should be exercised? So it was interpreted in a interest, general interest. That was the view of the Supreme Court. It was in a general interest. And this can be a law under 142, which is binding upon us.
There is no declaration of honorable apex court that 142 is a.
Okay, come back at
Sundar Bhai is a-
this will be the question. Will
My learned friend definitely has a thesis, to which I have my own antithesis. And my learning is synthesis. Synthesis will come from the error.
we will not synthesize. We will say that I have not been able to synthesize these two views, not reconcilable. Or if Bora can satisfy us, this no.
I think the last question my learned senior tried. I don't know whether my learning is satisfied or not.
We are a little bit inclined. But we'll hear again today,
On 12th, my
Bora,
because they have got. their
because
say.
both of you do not like to be, post-class session is not good for both of you.
No, my lord, I can
From tomorrow being 5 days
No,
holiday.
my lord, I can continue today also. I can.
No, from tomorrow, 5 days being holidays is important for me, because if we can conclude this,
Yes, my learned can deliver on that.
That's why I can conclude. If they conclude, I'll take only 10 minutes.
I
Let us-
take some time.
okay, let us continue.
We'll
We'll see if it is not possible, we'll continue. Who can?
Today I just, whether the know the contention of my learned senior.
No, it will not take, you are having 1 hour now.
My lord,
We'll ask you also questions.
I will just, start on that point, my lord, 450 and 457. The difference. I will show the difference, not the judgment, my lord.
No, difference we know. But problem is, the principle on the basis of which it is said that 457,
In fact, my lord, vehemently argue before division bench that Ram Prakash Sharma is not applicable in this case. Because Ram Prakash Sharma, there was no ratio tender. That was an order, that was not a judgment. That was an order to
So
give custody.
for that, you need some judgments. For your interest also. Okay, we'll continue at 2.
Public.
But I have not completed today because I.
No, you be listener today.
Wow. आणि इसके पैटर्न दिखा जैसे कि हाँ नहीं बेल है
Hello. Một cái nó sắp rồi. Rồi đó con này.
No, thanks. he said. जल्दी कुछ है बेल के लिए लोग पहले ये देखो कंटिन्यू करेगा
Yes, David. Serious injury. He says you have beaten up by cable. The medical evidence says serious injury with clotting blood and injury by cable. The doctor opined. CD.
There's accident. And police is also there. Kindly have a look, page 9, kindly. Page 9.
We have seen it.
IO has submitted them. I beg to report that both the parties are involved in violent movement. Page 9.
But he's beaten up by cable.
Well, that is subsequent, my lord. It was dated by section is dated subsequent.
The medical report concerned Dr. opined that major injury and fresh bleeding at right eye found at the time of examination caused by blunt object of car cable.
It is subsequent.
And his FIR is that he was beaten up by cables.
But there is a side, man. That is
CD.
kindly some protection, man.
You can reject on the FIR itself. Don't go further. Yes, next case.
Sorted, man.
14.
two attempt two
Yes, Gary. No interim, Mr. Sarma.
He is working as a teacher in the private school. And my lord,
This is what he has done is not expected.
entire is a people subsequently go to the entire.
Many things are false of this affair. Many things are false. We are also aware, many facts are false. These are exaggerations. But you have done that.
But I have some positive because they were to be so Facebook. They were in talking terms. And what is the what he is stated, he has stated in the affair and that he is person. However, the
Not all things fabricated. She thought that, let me add some exaggeration, but this is not expected. If you are a teacher, then to know interim.
they were not to each other, that is fact.
That is a fact.
That I am not denying that.
Yes.
But
But you are having some relation in different hotels, that also we don't have any problem. But threatening her with releasing her private photos, we have serious problem on that.
it is not a.
Whatever you do inside this is your privacy. But if you take advantage of that, that is the allegation.
The petitioner went to the police station. And the police officer asked both of them to settle the dispute.
Oh, forget it. Police will say many things. This is not a case, Mr. Sharma.
Father, my suggestion
We are very liberal in granting interim, but this is not a case of interim. More particularly in these cases.
he is a school teacher. He is now, for example, one or two is very very. After
On 8 case there. Yes, next case.
three
Yes. One is the informant. 2 is the husband, 3 is the wife, disposed of Lakshmi Narayan.
Item 4,
No. Yes. Case diary.
Maybe, 11, I got idea.
11.
11.
11? Yes. Huh?
should be
Okay. At number 2, in common. 2 number 2 husband, 2 number 2, they were major, she was major at that time. So other matters are over, only this. All baki, all are Jimmas.
Kashmir's
Password is also maybe.
engineering details.
Okay. We'll see the hearing. Yes, continue.
My lord, complete my lord, pardon. My lord, has already seen now how the decision that method was referred to. These are the 3 orders.
Hmm.
These are the 3 orders passed by single benches.
Hmm.
Criminal section 284 of 2020. Sorry. no. Criminal section 597. Same issue was raised. Because of the entire judgment. Paragraph 11.
Of
Is the case of criminal section 597.
597.
Paragraph 11.
One aspect, all fine. See,
What, why I am pointing this?
see, just this is not related to this, may not be this case. See a situation now. This husband Patel. The object was to that this property should not be wasted or something like that. Now you see the situation before this court. Instead of hearing 2009, 2005 matters where people are still behind bar. Just it's not part of this thing. Yesterday, somebody came, already period over 10, after 10 years matter was listed for hearing. The Climate Council says that not insist on the merit, already she has done. I have gone through the record. It's a clear case of acquittal. 10 years. And we are devoting our time. Now we'll have to devote our time on Jimmas. Anyway, continue.
On that, my lord, yes, I mean, firstly, my lord, because of the fear that it exists today, there is no power of review by any court. Not even.
Well, just it's a passing comment, nothing more, nothing.
Session just been equipped with 482, my lord, sir. Burden of dishonorable court has been.
Not only burden, anyway, you proceed. Sometimes law creates difficulties for the common man. Let's continue. Yes.
Why I was pointing out these judges, sir, because there are 3 honorable judges
Hmm.
who concur with that same view.
Hmm.
As in the court.
No quarrel, you argued a case that is regarding that was a better case than this for you. That was a case relating to
Forest right.
forest royalty. Here I wrote 3 per paragraph why there should be consistency in judgment. when the adjustment is followed. There is no quarrel on that. That you need not argue. That
Then my,
is first point, that point you need not argue. Second point, division bench judgment. As a division bench judgment, it is binding upon this court. Third case is that I cannot refer it to be a par victoria. But there is other aspect which Mr. Bora is addressing that somehow is, I want to better enlighten on that. Otherwise, otherwise, my view is that even if the judgment is there, division bench, this court in its revisional power can
grant custody.
grant. That will invite many cases to us like bail, we'll handle it. That is not an issue. But this is clear, this is clear.
Regarding the law laid down.
Ah.
To be guided.
Now you tell us how to handle this judgment in two different situations where provisions are similar. You handle, you as an additional advocate general, you tell us how will you handle, how will you say that this is the ratio? So enlighten us what is the ratio of the division bench judgment so that we can rely on it. That this is the ratio of the division bench.
In a way, that means minority is again testing the method.
No, let us, I am not testing.
Has expressed that minority is not going to.
No, I am not
override the
testing.
judgment.
No, you say us that how to handle with this division bench judgment saying that 451, this is the difference between 451 and 457. Therefore, in 457, magistrate will have a power, 451, magistrate will not have a power. This is the ratio laid down in the paragraph so and so of this judgment. Help us so that we can dictate this judgment.
That my submission would be
Hmm.
that if there is two different set of ratios laid down in identical, for identical provisions, the better course of action is to refer it
So argue that.
refer it to the Honorable Indian Judge.
Argue that, then you argue that this judgment is not binding or this is creating a problem because two ratios laid down. We
There are
wanted,
two ratios.
you argue that,
There are two ratios.
you argue that, give this court a handle.
Exactly.
Because this is otherwise a binding precedent until and unless you argue that no, this is not, this cannot be a binding precedent because this has laid down two sets of ratios. Tell us that. It cannot be, then it cannot be a binding precedent.
So what I'm saying,
Tell us.
what I'm saying is, my argument would be, my lord, the ratio for 451,
Hmm.
there's no custody during investigation, what to have been the ratio for 451.
So if that be so, according to you, the division bench judgment, if there is two ratios laid down which is opposite, then it is not be a binding precedent.
Then even if it is not binding precedent, then it has to go to the other.
So argue on that. That is why what I'm saying is that please help us concluding that this is the ratio of this division bench judgment. You are saying that 451 is not applicable, 457 is applicable. And you are saying that no, 450, the ratio laid down in respect of 457 ought to have been applied in 451. 451. And Mr. Bora will say that
Both is not applicable.
457 is applicable, same ratio, same parameter provision 451.
For that, my lord. for that,
So
we have to go
two
to-
arguments are coming.
Exactly. My
And
argument-
both the opposing parties are saying in the same voice that ratio is two ratios laid down. Now you address us in that situation, what a single judge should do.
Exactly. My lord, 2018.
2000,
810 is phase one.
phase one,
Phase one. Copy that.
official liquidator. Just give me a minute.
Official liquidator versus Diana. 2008 volume 10. take up 75.
So that's the number.
75.
It is so slow.
75.
2000
8 voluntary. Phase 1.
phase 1.
Paragraph 2, paragraph 75. Paragraph finds at phase 50.
Paragraph 75.
Where is it? Phase 5.
Huh.
By virtue of Article 141 of the Constitution, the judgment of the Constitution bench in state of Karnataka versus Jumadevi
Hmm.
is binding on all courts, including this court, till the same is overruled by larger bench. The ratio of the Constitution bench judgment has been followed by different two judge benches for declining to entertain the claim of regulation of service made by ad hoc temporary daily wage scheduled employees or for reversing the orders of the High Court granting relief to such employees. These are the cases in Indian Drugs Constitution. However, in UP SCB versus Poonam Chandra Pandey, on which reliance is still placed by Sri Gupta, a two-judge bench has attempted to dilute the Constitution bench judgment by suggesting that the state system cannot be applied to a case where regulation has been sought for in pursuance of Article 14 of the Constitution of India, and that the same is in conflict with the judgment of the five-judge bench in Maneka Gandhi versus King of India. Para 76 line.
Mm.
The fact of UPSCP versus Poonam Chandra Pandey, where that the respondent 34 in number were employed as the daily wage employees by the Cooperative Electricity Supply Society in 1985. Taking was taken over by Uttar Pradesh Supply Board in 97, along with the daily wage employees. Earlier to this, the Electricity Board had taken a policy decision on 28/11/96 to regularize the services of employees working on daily wage from before 4/5 to 1990, subject to their passing the examination. The respondents used the High Court claiming benefit of the policy decision dated 28/11/96. So, learned single judge of the High Court held that once the employees of the society become employees of the Electricity Board, there is no valid ground to discriminate them in the matter of regulation of service. The division bench approved the order of the single bench. A two-judge bench of this court dismissed the appeal of the Electricity Board in para 11 of its judgment. The two bench distinguished state of Karnataka versus UP by observing that the ratio of that judgment cannot be applied to a case where regulation has been sought for in pursuance of Article 14 of the Constitution. The two-judge bench then referred to these judgments. 16, we are constrained to and observe 16, we are constrained to refer to the above decision and principles contained therein because we find that offense Umadevi case is being applied by courts mechanically as if it were a illusive formula without seeing the facts of a particular case as observed by this court in Bhavnagar University and Bharat Petroleum Corporation Limited. A little difference in facts or even one additional fact made a lot of difference in the presidential value of a decision. Hence, in our opinion, Umadevi case cannot be applied mechanically without seeing the facts of a particular case, as a little difference of facts can make Umadevi case inapplicable to the facts of that case. We may further point out that the seventh bench decision of this court in Maneka Gandhi versus Union of India has held that reasonableness and non-arbitrariness is part of Article 14 of the Constitution. It follows that the government must act in a reasonable and non-arbitrary manner. Otherwise, Article 14 of the Constitution would be violated. Maneka Gandhi case is a decision of 7 bench, whereas Umadevi case is a decision of a 5-judge bench of this court. It is well settled that a similar bench decision cannot override a larger bench decision. Smaller bench decision cannot override a larger bench decision of the court. Note that Maneka Gandhi case does not specifically deal with the question of regulation of government employees, but the principles of reasonableness in executive action and the law which it has laid down, in our opinion, is of general application. We have carefully analyzed the judgment of the two bench in the Poonam Chandra Pandey case, and we are of the considered view that the above reproduced observations were not called for. The only issue which failed for consideration by the two bench was whether the daily wage employees of the society, the establishment of which was taken over by the electricity board, along with the employees, were entitled to be regularized in terms of the policy decision taken by the board, and whether the High Court committed an error by invoking Article 14 of the Constitution for granting relief to the request. The question whether the electricity board could frame such a policy was neither raised nor considered by the High Court. Fine, I will skip this. I will take your lordship to paragraph 86, sorry, 84. In the state of Bihar versus Kalika Kaur, the court elaborately considered the principles of par inferior and held that earlier judgment of a larger bench cannot be ignored by invoking the principle of par inferior, and the only course open to the co-exercise bench or similar bench is to make a request to the reference to the larger bench. In the state of Punjab versus Devan's Modern Breweries Limited, the court reiterated that if a co-exercise bench does not agree with the principle of law enunciated by another bench, the matter has to be referred to a larger bench. In the Central Board of Diwali Hora Committee so, the Constitution bench interpreted Article 141, referred the various earlier judgments, including Bharat Petroleum Corporation Limited and held that the law laid down in a decision delivered by a bench of larger strength is binding on any subsequent bench of lesser or co-equal strength. And it would be inappropriate if a division bench of 2 judges starts overruling the decisions of division benches of 3 judges. The court further held that such a practice would be detrimental not only to the rule of discipline and the doctrine of binding precedent, but it will also lead to inconsistency in decisions on the point of law, consistency and certainty in the development of law and its contemporary status. Both would be the immediate casualty. Paragraph 88, In UP, Gram Panchayat Adhikari Sangh versus Dayaran Khalod, the court noted that by ignoring the earlier decision of a co-exercise bench, a division bench of the High Court directed that part-time QPL operators should be treated as permanent employees with some service conditions as far as possible and observed. Judicial discipline is self-discipline. It is an inbuilt mechanism in the system itself. Judicial discipline demands that when the decision of a co-exercise bench of the same High Court is brought to the notice of the bench, it is to be respected and is binding. Subject, of course, to the right to take a different view and to doubt the correctness of the decision, and the permissible course open is to refer the question or a case to a larger bench. This is the minimum discipline and decorum to be maintained by judicial fraternity. Paragraph 90, my lord. We are distressed to note that despite several pronouncements on the subject, there is substantial increase in the number of cases involving violation of the basic judicial discipline. The learned single judges and benches of the High Courts refuse to follow and accept the verdict of law laid down by coordinate and even larger benches by citing minor differences in facts as the ground for doing so. Therefore, it has become necessary to reiterate that disrespect to the constitutional ethos and principle breach of discipline have great impact and credit on the credibility of the judicial institution and encourage a chance litigation. It must be remembered that predictability and certainty is an important hallmark of judicial jurisprudence development in this country in the last 6 decades, and increase in the frequency of conflicting judgments of superior judiciary will be an incalculable harm to the system, in as much as the courts at the grassroots will not be able to decide as to which of the judgment lay down the correct law and which one should be followed.
That is the problem we are facing.
That's why Malak has to be referred.
That is the problem we are facing here.
We have to that is to refer that way.
Refer whether a division bench, whether this court can refer it.
Minor can in the administrative side places for almost the order passed in.
Anyway.
Paragraph 91. We may add that in our constitutional setup, every citizen is under a duty to abide by the constitution and respect its ideals and institutions. Those who have been entrusted with the task of administering the system and operating various constituents of the state, and who take oath to act in accordance with the constitution and uphold the same, have to set an example by exhibiting total commitment to the constitutional ideals. This principle is required to be observed with greater rigor triggered by members of the judicial fraternity who have been bestowed with the power to adjudicate upon important constitutional legal issues and protect and preserve the rights of individuals of the society. Discipline is sine qua non for effective and efficient functioning of the judicial system. If the court commands others to act in accordance with the provisions of Constitution, the rule of law, it is not possible to countenance violation of the constitutional principle by those who are required to lay down the law. In the light of what has been said above, we deem it proper to clarify that the comments that was interpreted. Then, my lord, 2002, volume 7 estate. 2002 volume 7 estate. Page 2.
Paragraph.
Paragraph 5. Delhi administration versus Monovala. Paragraph 5. May I read?
Yes, paragraph.
5, madam. We have carefully considered the submissions of the learned counsel appearing on either side. Apparently, the learned judge in the High Court was mere swayed by considerations of judicial committee and propriety, and failed to see that merely because this court has issued direction in some other cases to deal with the fact situation in those cases, in the purported exercise of its undoubted inherent and plenary power to do complete justice, keeping aside even technical things, the High Court exercising statutory powers under criminal laws of the land could not afford to assume to itself the power and jurisdiction to do the same and similar things. The High Court and all other courts in the country were no doubt ordained to follow and apply the law declared by this court, but that does not absolve them of the obligation and the responsibility to find out the ratio of the decision and ascertain the law, if any, so declared from a careful reading of the decision concerned, and only thereafter proceed to apply it appropriately. In the cases before them, considered in that context, we could not find from the decision reported in so and so any law having been declared or any principle of question law having been decided or laid down therein, and that in those cases this court merely proceeded to give certain directions to the disposal of the matter in the special circumstances noticed by it, and the need fell
In those cases.
cases by this court to give such a disposal. The same could not have been mechanically adopted as a general formula to dispose of as a matter of routine. All cases coming before any or all the courts as a universal and invariable solution in all such future cases also. The High Court had no justifying reason to disturb the conclusion of the first appellate court in this regard. This is just why I am referring my lord not take Sundar Ambala for an opinion. 2002 voluntary.
But we'll have to do same thing in case of earlier judgment also.
That my lord has passed on.
No, that 450, on the basis of which the 457 is said that there is a power under 457. We'll have to rely that Ram Krishna or something.
To that effect, I have filed a written argument, but some of my submissions did not find place in the document. If we see Sundar Bhai Ambala, my lord. Ambala. Paragraph 2. It is the prosecution version as per FIR laws on 7/2002 by the Assistant Commissioner of Police D Division, Surat, that the petitioners and other police personnel are involved in offences punishable under section 429 so and so of IPC. It is alleged that when they were working at various police stations, they had committed offences during the period from 1992 to 23/11/2001, almost 11 years now, by replacement of Mudamel articles, including golden ornaments by other spurious articles, misappropriation of the amount which was kept at the police custody, unauthorized action of the property was seized, which was seized and kept in police custody pending trial. That was a compelling situation created by these police personnel. Pending trial and tempered with the records of the police station. Now, my lord, if we come to paragraph.
No,
now,
that was a trial, different trials were going on. In those trials, these things were seized. Now they misuse this, that.
Agree.
Then thereafter, they were arrested and
During their
trial court granted remand of the petitioner to police remand. Now against that, they come to the High Court. High Court also rejected. Against that special petition is filed.
then these things came up.
There's this
And my lord has said in this judgment, there is no issue framed regarding the state in which custody can be granted.
no specific issues,
No
no
specific-
quarrel on that.
No deliberations to that effect. No deliberation. That is why the last judgment I am referring to.
Mm.
The last judgment will indicate that this is not a law to be applied in every case. There are judgments, my lord, wherein in respect of forest, in respect of excise, since the authorities have a power of confiscation, not only seizure. So it has been directed by honorable apex court not to grant custody as a matter.
It is
So-
also given here also, in Sundarlal, here also, said that in certain cases, they will have to, 2-3 options are given. Hand over, don't hand over, if or not, nobody, then hand over to this, then confiscate or dispose of.
Exhaustive judgment, dealing with every aspect of the matter. For
Sundarlal.
example, my gun is seized. Can I go to the court and say, give me the gun by which I have committed murder?
So that is also dealt in Sundarbhai,
Exactly. Some of the issues are they dealt with.
yes.
Not every eventuality that may arise have been dealt with. Paragraph 4, my lord, can.
Yes.
The learned counsel further referred to the relevant sections 451 and 457 of the Code of Criminal Procedure, which read that. These are quoted 451, 452. Then, my lord, paragraph 5.
Hmm.
After reading down this, after quoting this, my lord, honorable apex court read down.
Hmm.
What it read down, my lord? Section 5, paragraph 5. Section 455 clearly empowers the court to pass appropriate orders with regard to such property, such as number 1, my lord,
Hmm.
for the proper custody pending conclusion of inquiry and trial.
Hmm.
The honorable apex court would have inserted investigation there also, my lord.
Okay,
That is direct reading of the section 451, 457.
okay,
So investigation part is silent.
Hmm.
Because there is no issue frame to that effect.
okay, then. To order to be sold, otherwise disposed of.
After recording such evidence as it thinks. Then my lord will kindly come to paragraph 8, my lord. I'll skip this page, my lord, to the 87 page, my lord, we'll skip next page, that paragraph 8. The third line, my lord, the line.
Just a minute, just a minute. Now kindly come to paragraph 7.
Right.
Don't skip paragraph
In
7.
our view, the powers under section 451 exercise expeditiously and judiciously. It will serve various purposes, namely, honor of the article would not suffer because of its remaining unused or by its misappropriation.
Okay.
Court or the police would not be required to keep the article in safe custody. If the proper panacea before handing over possession of the article is prepared, that can be used as evidence instead of production before the court. Before the court during trial, if necessary, evidence could also be recorded describing the nature of the property in detail. Is jurisdiction of the court to record evidence to be exercised promptly so that there may not be any further chance of tampering with the
Okay. Now we want to paragraph 8.
paragraph. Might be kindly turn to next page, paragraph 8. The sentence, the line starting, the sentence starting with the word, madam, as the seizure. Third line,
Paragraph 9.
paragraph 8, madam. As the seizure.
The question of proper so and so, so and so, so and so
Then there is one subparagraph starting with 4.
for us. The object and scheme.
Yes, I'll start from here. The object and scheme of various provisions of the code appear to be that where the property which has been the subject matter of an offense is seized by the police, it ought not to be retained in the custody of the court or the police officer for long or any time longer than what is absolutely necessary. A seizure of the property by the police amounts to a clear entrustment of property to a government service. The idea is that the property should be restored to the original owner after the necessity to retain its season, it is manifest that two eventualities honorable apex court has said, well, it is manifest that there may be two stages when the property may be returned to the owner. In the first place, it may be returned during an inquiry and trial, no investigation. But my lord will now see the second step. This may particularly be necessary where the property connected concern is subject to speedy and natural decay. There may be other compelling reasons which also
May justify.
may justify the disposal of the property. So it is not exhaustive. And for my lord, property which are subject of, which may be subject to speedy and natural decay, there are separate provisions for it. There are separate provisions. That is why I am saying, my lord, as regards the issue that has been decided by the division bench,
Hmm.
there is no adjudication whatsoever by the honorable apex court in the case of Sundar Bhai Ambala.
Okay,
If now my lord comes to the division bench judgment again,
just a minute.
Right.
How do you interpret this paragraph, paragraph 10 of Sundar Bhai?
to avoid such a situation in our view, powers under section 47 should be exercised promptly and at the earliest.
What do you mean by this? Promptly and earliest.
Once investigation is completed, immediately.
Okay, now let us come to the next.
With regard to the valuable articles such as gold, silver ornaments or articles studded with precious stones, it is submitted that it is of no use to keep such articles in police custody for years till the trial is over.
Hmm.
Till the trial is over, ma'am. In our view, this submission requires to be accepted. In such cases, magistrate should pass orders as contemplated under section 451 at the earliest. At the earliest is at the conclusion of the investigation. As per CRPC itself, my lord, investigation ought to be concluded within 24 hours.
So according to you, that earliest should be promptly and earliest should be read immediately after inquiry trial commences. Commences, okay. Now, there are some period, specifically some period is given in some cases. I forgot where was it. Huh? Where is that?
It is the last paragraph, madam.
Last.
Paragraph 21.
20.
21, madam. However, these reports are to be exercised by the magistrate. These powers are to be exercised by the magistrate concerned. We hope and trust that the magistrate concerned would take immediate action for seeing that powers under section 451 CRPC are properly and promptly exercised and articles are not kept for a long time at the police station. In any case, for not more than 15 days to 1 month.
How do you interpret this?
No, it is not safe, madam. In any case, for not to 1 month. It has always said, madam, that after seizure.
But how do you read, then according to you, suppose investigation goes on. It's not necessary that investigation is over by 90 days maximum. So all the views expressed by this case in Sundar Bhai Ambala, that what is the object of protecting that property. So first part is wiped out. They only when trial is commenced, from then only 15 to 1 month court is duty bound, but police is not.
Police is yes, madam. Because under 102 for the first time in 1973, police was granted power to give custody. For the investigation stage.
So you say that this principle of Sundar Bhai must be read to the power of the magistrate during inquiry and trial. Inasmuch as the anxiety expressed in Sundar Bhai Ambala is taken care of, and that principle is required to be applied by police under section 102.
Madam, kindly please 102.
Yes.
Exactly very much. Power of the police officer to seize certain property. Any police officer may seize any property which may be alleged or suspected to have been stolen or which may be found under circumstances which create suspicion of the commission of any offense. Such police officer is subordinate to the officer in charge of the police station shall forthwith report the seizure to that officer. 3. Every police officer acting under subsection 1 shall forthwith report the seizure to the magistrate having jurisdiction, and where the property seized is such that it cannot be conveniently transported to the court, or where there is difficulty in securing proper accommodation of the custody of the custody of such property, or where the continued retention of the property in police custody may not be considered necessary for the purpose of investigation, he may give custody thereof to any person on his executing a bond undertaking to produce the property before the court as and when required, and give effect to the further orders of the court as to the disposal of the. So that's an interim process. Investigation says custody is taken care of by 102, which was unknown prior to 1973, because the earlier CRPC might have contained the power of seizure only.
What the new draft says?
New draft is difficult to spell even. The main CRPC, I don't know what is their name, madam,
Samhita.
like that.
That's
We
what.
will make it in short form, madam.
Yes. Yes.
Then some proviso malleability. Provided that where the property seized under subsection 1 is subject to speedy and natural decay, and if the person entitled to the possession of such property is unknown or absent, and the value of such property is less than 500 rupees, it may forthwith be sold by auction under the orders of the Superintendent of Police and the provisions of 457, 415 shall, as nearly as may be practicable, apply to the net proceeds of such thing. So investigation part pilot taken care of by 102. If now my lord tell you this the division bench judgment.
Division bench judgment. Yes. Yes.
Paragraph 34. Paragraph 34. In case of Sundar Bhai Ambalal Desai, the apex court has considered the judgment of the apex court in so and so. Srimati Basava, so and so, and held that the magistrate to take immediate action under the section so and so. I'll skip this one, last part, next page one. Rightly or wrongly, the division bench is saying, the apex court in the case.
So in paragraph 34, what is concluded by division bench is that
Sundar Bhai
Ambala, it was a dicta of that magistrate should take immediate action and to see that the said articles were not kept at the police station for more than 15 days to 1 month from date of seizure. Now, from if that is the interpretation date of seizure will be done when investigation is going on. So
despite this, the ratio is different.
that is why.
That is why also I'm showing it.
Because this is the 451, the division bench laid down that the division bench interpreted Sundar Bhai so far relating to 451 that it is the magistrate in terms of the dictum of Sundar Bhai, you at the earliest you should do and not beyond 30 to 50 days.
Then
So
my-
therefore magistrate will have a power.
But this is an observation, this is an officer. Ratio is different, man.
No. This is not observation. This
This
is
is observation, man.
this is observation. But ratio is
Ratio
based
not-
ratio is based on what?
That is what I'm saying, well, ratio is not telling you to observe it. That's why I'm saying, well, 457 also should be taken, even the same set as the 451. Next, Milo will see last part of this paragraph now.
Instead of that, if this is the finding that Supreme Court has said that it is to be done at the earliest, it is the view of the learned division bench. While interpreting Sundar Bhai, same should be applicable to 457.
But that is not a ratio now.
Because 457, according to the division bench, is magistrate is having power.
Agree.
According to the division bench, in 451, magistrate is to do within 30 days. So therefore, that line is obiter. 451 is obiter, not ratio.
No, man, cannot, that's a, obiter is this, ratio is different.
So if this is obiter, then how you reconcile?
This obiter is followed by other obiters also. For
Yes.
example, the last part of this paragraph, para 30,
Yes,
para 32 last paragraph, well, after this quotation, well,
Hmm.
the apex code in the case of Sundar Bhai, Ambalal Desai did not go into the question whether section 457 could be applied by a criminal code in stage of.
no doubt on that. No doubt on that. So court did not rely on for Sundar Bhai Ambala so far it relates to 457. Rather court relied on the earlier judgment. What is that? Ram Kumar or something. To Ram Prakash to conclude that the magistrate will have power under 457. So therefore, the last line is having a contradiction with the determination of paragraph 34.
Easiest line. I understand, but that may be the easiest. If a custody under 47 and 457. While doing so, will this court, my lord, insert the word investigation in 451 and 457, which is not there.
Will not insert.
If effectively it will be inserted.
Will not insert. But what about the division bench judgment? So far relating to 457 is binding precedent according to you.
So division
And
bench has inserted
The
investigation
paragraph
in
34 is also binding upon this court.
division bench has inserted
So
investigation in
therefore,
457.
to have a proper reconciliation, we'll have to say that the only single line is not the ratio.
That it will be better now if it is led by division bench.
Then we will say it is because we'll quote this paragraph,
My lord,
how it was
because
interpreted.
in fact, this paragraph is quoted again from Sundar Bhai.
Sundar Bhai.
Sundar Bhai
Sundar Bhai.
exactly says this.
Court,
Sundar Bhai also said
the division bench says, so far relating to 451, we have no problem. If we read page 34, no problem. But so far relating to 457, Sundar Bhai is silent. So let us deal with 457 on the basis of Ram Prasad.
that is
So
the
now-
easiest road for the
so-
court, my lord.
So Ram
That is
Prasad
the easiest road for the
relied on
court.
Ram Prasad. The moment it's relied on the Ram Prasad and paragraph 34, if we have to reconcile, we will have to say that a single line.
Then effectively, my lord will be inserting investigation. Division bench committed one error in inserting investigation in 457. Next error will be.
That is
done by our-
binding upon us because division bench says paragraph 34 says that Sundar Bhai Ambala is applicable. So far relating to 451. So if once the Supreme Court division bench says that so far relating to 451, Sundar Bhai Ambala is applicable, that is binding upon us. Not only that, Sundar Bhai Ambala itself is binding upon us.
Because Sundar Bhai Ambala has not decided on the issue of stage of granting custody. There was no legal.
But division bench has interpreted,
No, no, division
saying
bench-
that you will have to do
My lord,
within
division
1
bench
month.
says, my lord,
And if we go to the CRPC, there is no scope of completion of in any provision within 30 days,
no, there
any
is no-
investigation, either
That is not,
either 60 or 90.
no, that is why I love this law was changed. I'm coming to it. 167 here. What the legislature contemplated, that
Yes.
cannot be the practical.
Yes,
167. procedure when investigation cannot be completed in 24 hours.
Hmm.
So presumption is that most of the investigation will be completed in 24 hours. It cannot be completed 60 days and 90 days.
60 days and 90 days. So then why division bench interpreted that magistrate under 451 to exercise its power within 15 to 30 days
Because that is why I'm
from the date of seizure?
That is why I'm saying, Sundar Bhai is a judgment. It's a judgment. These issues were not framed.
Because in
Not
view of your judgment relied on by 2002 and 2008, I am bound by this decision, paragraph 34, interpreting Sundar Bhai. I cannot reopen it.
Interpreting Sundar Bhai, division bench has passed an order, madam. Interpreting rightly or wrongly, division bench has passed an order.
Division-
That is minor is now
Division bench clearly says, so far relating to 451, this has been done by Sundar Bhai. However, Sundar Bhai has not dealt in 457. So therefore, let us deal with 457, and while dealing with 457, relied on Ram Prasad and said Ram Prasad.
That is the it is the less partition, less deliberate. But that may not be the correct way.
Isn't it?
That may not be the correct way. That will be the easiest, will be saving time on. But madam, that may not be the correct.
Okay, we'll not save time, we'll hear you.
Or madam, the case of 12, everybody has got their vehicles by now. That is, Mr. Bora is happy,
Everybody is having vehicle except Madam.
Predictable, there are separate person, they can make application that can be granted.
So your things are all Vittalnaths. Which are the cases give me? And what is your case, Mr. Factually?
Actually, they have not arisen to grant.
To grant. So according to, so 451,
There is a judgment of honorable minor SKMD, wherein the honorable court has said that instead of going on to all these things, they will auction it, they will realize the amount, it will be kept in the treasury. Once the trial are over, subject to the outcome of the trial, either they will get or we will. That's the best course of action.
cannot be.
Yes, well,
They may not get the proper price in auction.
public auction.
No, this supari can be used for other purposes. Even if it is not human consumable, this
Can
can
be
be
used for manufacturing of colors.
many other parts. Then they will get much more money. What is the purpose of keeping those Vittalnaths in your custody?
Because my lord, to otherwise we are not on crossing now. I'm not on the validity of the section. What I am basically on, madam, their modus operandi is two types. One is, madam, with Burmese super and even least Indian super. So it is very difficult to find out which is of what origin. Secondly, our survey says the value of a supari is around at the time, at least in last year, was around 400 rupees. They show it to be purchased at 200 rupees. They pay GST on 200 rupees, and rest of the 200 rupees GST they evade.
Now, this is whose responsibility is this?
That's why we are arresting them, we are seizing them.
Under what authority?
That is why I'm saying, we are not on crossing. Nobody has come on crossing.
On what authority can you do this?
Crossing of FIR.
But we'll take note of this 482. Under what authority? There is a division bench judgment saying that moment it is said it is of foreign origin, your jurisdiction is out. Makhon's jurisdiction is out.
Not foreign original, mixed with the local.
There is not a single FIR. I am sitting here for almost 4 weeks in criminal base. Not a single FIR where it is said that they have mixed or this is local or this is tax evasion. Nothing. None of the cases.
But, that's why-
The only case is that this is a Burmese supari. It has come from this and this. Okay, Burmese supari, hold it, inform it to the custom. Custom will do whatever is necessary.
Basically, to extract the revenue. They will find them and they will allow it.
No, not only revenue. Custom can even sell it, confiscate. All power is there. That is absolute. Moment you say that it is of a foreign origin, that jurisdiction, even investigation, power of arrest, everything is there.
That he was taken in respect of exotic animals. That is only the custom. It was negated by.
No, not custom, supari. It's a division bench judgment from, in Aizawl bench. Isn't it?
12.
Mr. Mora? Yes.
Things are not going in my direction now.
Huh?
I have to do this.
40 meters are fixed on 12. He's, I have not taken view, but I am,
But I can swear well.
it's not, judges, this will change.
Only difficulty, practical difficulty for a lawyer, madam. Criminal petition for it is criminal jurisdiction. There is no intra-court appeal also, madam.
We know that.
Difficulty for us.
Know that, but the questions, I think, there are questions that coming to the mind of the court. Hmm.
After the judgment,
Hmm.
what is the current position, ma'am? The current position is very simple. For a Jimma, simply you have to file a petition under section 120. No. It would be trial court
Hmm.
under
457.
457.
457.
Because 457 having the power.
Power.
So everybody. So what is the, why they're objecting the 451? That is how difficult to
Because
know.
457, there is a rider, madam, if the item is not produced.
No, the rider is not produced because production and non-production not the issue. Is intimation.
Production is deemed.
Production is deemed because of the intimation.
Production is deemed.
That's because there is a judgment.
See,
The
why we're
production is
acting
deemed. The moment it is deemed, the 451,
451
457, which is nomenclature. Just the nomenclature we have to change in the transport. So,
That's why that day I said 75% of
That-
the order goes in my favor.
so in the cost title, if I change this to 451 to 457, I am entitled.
No, immediately submitted in Caesar report.
No, that's it. So what, if you can submit it, only the report.
Hmm.
The moment there is a report, the jurisdiction comes
Hmm.
under the 457,
Hmm.
because there is only the report is necessary. And in the 451, production.
Hmm.
And the report itself is a production.
Hmm.
Exactly.
So there is no
Only
distinction.
the distinction is the word.
It's the word only. Virtually there is no distinction. So why they are objecting to the 451? I don't understand.
No, they are not objecting to the 451. Their problem is the interpretation of division bench in 457. So in
It's
this,
not a- that is
and
so.
in
That
the-
was not challenged to the
No.
Supreme Court. So
so
why they have not challenged it to the Supreme Court? Because if that is the so, the 451 and the 457 is the same thing, only the nomenclature.
Hmm.
That they ought to have challenged it before the Supreme Court.
now
But
they
this is
want
not the law.
this court to say in their favor, saying that the principle of 451 as decided by division bench.
Pilot has extra pilot is open for both the.
Both. So,
But
yeah.
I'll both of you, but from the judgment, I'll show you
Hmm.
where they are wrong. Where they are absolutely, they have not read the properly, the provisions of the CRPC. Probably they are reading it upside down.
Hmm.
That is my assumption. That is why what is happening. Because they have not read all the provisions properly, that is the travesty of the justice happened in the judgment, in the division bills. This is absolutely travesty of the judgment. Because it was not placed, it was not placed properly before the division bench. That's why this is injustice has been
We will
caused.
record all this
Yes, yes.
and we will give a note.
Yes, yes. Injustice, no, justice, logically, I just need one answer from all of them.
Hmm.
Only one answer. The last paragraph, let us read it together of the
Sundar bhai.
Sundar.
Okay. Okay.
Only one paragraph.
Hmm.
Let us understand
Hmm.
why this is direction has been issued.
Hmm.
However,
The last paragraph is adjourned.
21.
Hmm. Hmm.
However,
Hmm.
these powers are to be exercised by the magistrate. Not to kindly mark every word here.
Hmm.
Powers are to be exercised by the magistrate. So there is a direction to the magistrate
Hmm.
concerned. Under what provision? Under section 451. We hope and trust the magistrate concerned would take immediate action for seeing the powers under section 451 are properly and promptly exercised and articles are not kept for a long time at police station. This is Lordship kindly marked at police station. Now, at this stage, while police station has come, if 451 comes, who is the custodian, madam? It's not the police,
It's
it's the
court.
court.
If it will be
Yes.
interpreted as
Yes,
that it is trial or inquiry, then it is the court.
it is the
Custodian
court.
is the court.
Then why? Why? The Supreme Court, the Alliance Supreme Court directed police that you release the article which is lying in the police station. When it lies in the police station, when after the inquiry, after the trial begins, no property which is being produced can lie in the police station. It is under the custody
Of the
of
court.
the court. The court is the custodial legis. Court is the custodial legis. They are not the custodial legis. That is why the Supreme Court said, the Supreme Court not said that is yes, because you don't have the power under 451, kindly release the article under 102. This why it's not been direction there that you release the article under 102. Let me complete it. I have not disturbed anything, Mr. So let me finish it. Why this police station comes into where from? Under 451. If that is the correct law, proposition of law, that is during investigation under 451, the court cannot interfere. Then that if it, that is be so, see, where is the article kept in the police station? During the investigation only they can keep the article in the police station. The moment it has been produced, or the charge, or the trial begins, or the inquiry begins, the courts become the custodian. Then the learned effect court would have been directed.
Expanded the scope of 451.
And
and 452.
then it should have been direction that the court, to the court, that release the article. It was direction not to the court. It was direction to the police.
Police.
So why to the police? Why to the magistrate? And Lordship kindly see one more thing.
Mm.
That is the diversity of justice. And a learned trial court
Mm.
who's trying or who's taking, before whom the production, the judgment, the article has been produced, he has no jurisdiction at all to decide the custody. And a small police officer, he will decide the custody. No,
Court cannot directly investigate.
no, the trial court, the magistrate can decide, but the police will decide to whom to give the custody. See, what is the irony? What is the irony?
Now, division bench at page 34
That is why-
interpreted
That is why I am saying.
in that way,
That way.
that to the police.
The police can decide the custody, but magistrate can't decide the custody. It's a very ironical situation. That's
No,
the way.
division bench at page 34
And the
say,
logic kindly see,
interpreted
what was the object behind the judgment? That is the prime.
prime, that is the prime.
That is the prime. What is the object? That is the model, the article, it should not be misappropriated.
No estate pending in the vehicle.
Whatever. It should not be misappropriated. See, what is happening? The police officers are changing the article, manipulating the documents, everything they are doing it. At what stage?
Sir.
That means,
Suppose
that means, well, logic-
in a lighter vein, suppose the tire of the gypsy is punctured,
Yes,
the petrol vehicle.
yes.
Bring the tire and hit it.
So now you, well, I'm not-
That's why
Yes,
in a lighter
that is-
sense.
that is why the logic kindly see, during investigation, that means if we agree by the proposition that the Sundarbai is not, investigation is not there, that means during the investigation, we have to presume there's no chance of any manipulation. Police is not, will change it.
So manipulation
That
is
only can be done
the,
when it was brought before the court only. So the court is responsible for the manipulation, for the articles, the changing, and the court is, that means court is responsible for the manipulation of all these things.
then why this police officer were arrested?
Then why they have arrested? Why? Then why they are saying that it
One case, this was the situation, right? There were
No, I am not on that. The judgment was not because of the one case. It is a direction to the all the courts, all the police stations.
It's a This is a binding precedent on all the magistrate. No, I am not saying because we are not exercising 451 power.
Yes, but now, but all the courts that since
There is no provision in the CRPC.
Then
That's
how,
the
then
problem.
why to the police?
why to the police?
Why not kindly appeal on?
So
There is
one
no
thing-
provision in the CRPC.
No, no,
That's
there's a provision, there's a provision in the police. So why, where we have committed the wrong? Because the understanding of all the three sections. The 451 has a different purpose, 452 is a different purpose, and 457 is a different purpose for a different stages. On the last occasion, I said 451 is the stage during the investigation, because at that time, there are two purposes. The court, there is extra power has been given to the magistrate to record evidence to decide the timber. Why? Why this extra power has been given under 451, which is not given under 457? Because it was already on the end of the trial. 457 is already in the end of the trial, which was not produced. The article which was not produced only reported 451, and during the inquiry and trial, that means what? The end of the till the end of the trial, it was not been produced. Only the report was made under the 451, 457, only report. That is why when the end of the trial, when the court will find that the some property which has been not produced, only reported, now we have to dispose it of. So he will decide the jimma of those articles under 457. So in that case, he don't need to go for an inquiry or take the evidence, because he already did the evidence recorded by him.
We will definitely disclose it.
Definitely will decide
Disclose
who is
it.
the disclosed, who is the owner of the property. So the 457, that's why the legislature is very clear. That's why no power has been given to record the evidence. Whereas under section 451, the special power has been given to record the evidence to decide the jimma. So why? That means, is it the case that there will be two different proceedings under the same court? One will decide who will be the owner of the property taking the evidence, and the other evidence will decide who the offense is. Is it the case? Is it the purpose? Cannot be. So that is why the legislature is very clear.
And
We
then
are under-
another object, 452, I think.
450, again, it was produced.
Hmm.
It was produced. But it was produced. That
But
was
no,
the
no.
distinction. That was the distinction. 452, yes, you can dispose of it. Which article? Which has been
Produced.
produced. And 457, not produced, only reported. That is why these are the three stages. First stage is the produced, 451. Nothing has started. 452, trial concluded, production.
So therefore, in Sundar Bhai, court was conscious of the fact
Fact,
that this was produced.
produced.
So therefore, moment is produced, you should not keep more than 15 to 30 days.
Maximum.
So and product,
And the direction was given
Hmm.
to the police,
Hmm.
not to the court.
Oh.
So why not to the court? If the 451, only power lies with the
and
court.
division bench rightly interpreted that Sundar Bhai Ambala paragraph 34.
Yes, and my contention is that as Lordship has pointed out, the last paragraph, the suddenly out of the blue, the division bench come to a finding that 451, there is no power. That observation, what is the reason for that observation? Where is that reason? A judgment without a reason, can it be precedent, binding precedent upon the other courts? The answer is no, because it is a sub.
More particularly in this case,
In this
when
case-
he read with paragraph 34 of the division
And
bench.
Sundar Bhai is only dealt with 451, not dealt with 457.
And
Well-
court were division bench went ahead saying that in Sundar Bhai 457 was not decided, so let us decide.
Yes.
Then
And it
proceeded.
decided on the basis of the Ram Prakash judgment.
Ram
That's a
Prakash.
different issue.
That's different issue.
But my case, my submission is that is suddenly out of the blue,
No,
without any discussion, without.
I
any
think it
discussion.
should be your argument that in fact, the division bench has decided at paragraph 34 that during 451 investigation, it should be given in by virtue of the judgment.
Only because of this, the last line of this, that particular line has created a problem. That is goes contrary to the earlier. So the last line, to justify the last line, that the 451, the court doesn't have the power, they must give it a reason. A judgment without a reason is absolutely no judgment at all.
No, judgment is with his reason. That
No, regarding 451,
Direct-
no reason, that the court doesn't have the
No,
power.
no. So far relating to 451, the court is silent. Division bench is silent because at paragraph 34, division bench has come to a conclusion that 451 we did not go. Already Sundar Bhai Ambala decided. However, in Sundar Bhai Ambala,
No,
457
that
not
is the
decided.
contradiction, my lord. Then again, why this?
Therefore, enlighten us that a single bench can ignore that single line
Yes, because that single line,
and with supporting judgment.
suppose that the single line, that is all I'm
It
saying.
is a single line.
Single line has absolutely no basis for that single line. There has to be some. basis.
Rather, the basis is against that line.
Yes, yes. So that line, when their single line, without any reason,
That can be a topographical error.
that's the easiest way. Then that is that has happened in one case in Bombay High Court. They couldn't decide where, then they ultimately they said it's a typographical error. Then because of that's a question of 60 days, 90 days case. Because of the Supreme Court judgment, then because if you go by the entire judgment, it is a 60 day case of a 60 day. That's it.
Judgment.
Entire judgment. Rajiv Chaudhary, after
Well,
paragraph 6, everything was favor of the Rajiv Chaudhary, but the paragraph 7, his petition was dismissed. So then the Bombay High Court said it is typographical error. It can't be dismissed up to the paragraph 6. So that's it, joking. But anyway, in my contention, the Sundarlal Bhai is very clear. And the paragraph 2, if we read it again, paragraph 2 of the Sundar Bhai is very clear. Not only trial, what is the word used? It's not only the trial. There. Now see. The paragraph till I'm reading the last few lines.
We have two.
Paragraph 2. Now see. It is alleged that when they were working in various sessions, they committed to offense during the period of censure by replacement of modal articles, including government ornaments, by other spurious articles, comma. Now you can see this comma. Misappropriation of amount which was kept in the police station, comma.
Unauthorized auction.
Unauthorized auction of the property which was seized and kept in the police custody pending trial. So these are all common, not. So these are the situation, my lord. All different situation has been projected by the Supreme Court. What are the different situations? So that's why I'm saying that we have part stay. So it is if we agree by their submission that this investigation is not part and it's by the judgment. That means my humble submission, all the magistrates are liable for the misappropriation, not the police officer during the custody. Because custody, only it can't be misappropriated during the police custody. They can't do anything. That's the judgment. The judgment is why the purpose of the judgment we have to see. Why the judgment has been directed to follow each and every code. The next one, the first one, this one, the next one when the insurance company came in to implement themselves. Then again the same
Yes.
their direction
Further
has been
direction.
given.
Further
Further two direction has been added.
What was that insurance company judgment?
So why this insurance company judgment has been further has been
What is the citation? Just tell me.
The next phase of the
2010 768. Where condition document.
Yes.
so the second judgment, the reiterating same thing, rather it is there is two more agency and there is a direction to the police again in the second judgment because now the situation, some of their vehicle has been hypothecated where Suppose the bank.
Hmm.
And they are not aware, police has not informed. Police has seized the vehicle but not informed. And they have kept the car. Because there is no one. And accused is not the owner. No one has to claim the property. And it was hypothecated property. It was not intimated to whom it was hypothecated, to the bank. In that particular situation, it was also the direction to the police that immediately, forthwith, under the MV Act, you inform. Why to the police during the investigation? So that the bank or the financial agency, they not lost the support. So that they can take the custody during
They
that
come and
period
apply
itself.
this. In
Not
fact,
to wait.
we have given a custody 5 days back to Tata Finance. He was
No.
not paying the loan, the vehicle was attached, Tata has come, saying that at least give
So
us
they
the
are the
vehicle,
exception.
no EMI,
So-
vehicle is been.
So why that direction against to the police under the MV Act? Why not to the court?
And there are some other concern of this. Group.
And what happens, my lord, in the case of the Pali?
Now the
What is
451
happening?
is shifted to this court by virtue of either in the guise of 482 or
And one thing, what is happening, my lord, is, as per my experience, what I am saying, the judgment was why relevant, my lord. In some of the cases, what the police officers are doing after seizing this supari, what they do actually, they pour water on the supari. So they damage the entire supari. So now again, when the report was called for, the report will come from the concerned, the authority, that it is not
human.
humanly consumed, fit for human consumption. Then the half the supari, they will keep it, it's not human consumption. So they will do it whatever they will.
And I have authored a judgment in division bench, sitting in a division
And
bench
what
in a
case?
custom case, saying that same thing argument of the custom was that this is not human consumable, so therefore it should not be returned back. We-
So-
We said that this is not your concern. Suppose a
So why
material
are
not
they-
is human consumable is used, there are some other
Yes,
agencies.
So that Sundar Bhai's purpose,
Hmm.
why the direction was there, even the police are using the same technique in a different way. They are not misappropriating the entire property now. They are damaging the property so that the actual owner does not get the property. And they take the other way around.
This is a mere information direct from his client, man.
No, I said it.
Not controverted.
I
by the
said-
other side, man.
No, I said it. This is my experience.
This is experience.
I said it. This is my experience.
He's not arguing that this is the reason
Yes,
for,
yes.
he's
I'm
not,
just, this is still going on. I can give you there are few FIRs also against the police officer. Recently in the Sansari, they have registered 2 cases.
no, Mr. Goswami's interest is for forest.
Airport supervisor,
Which department relates to Supari?
police, home department and police.
Okay. We are more concerned with the Supari.
He was entrusted for the Supari. It's called Supari killing. All right.
14th, father.
14th.
Obliged.
But we'll have to answer the paragraph 34 and the last line.
And confident number. I think I will be for that. That's right. It's good.
Hard in part, list this matter for further hearing on 14th. Which set of matters, please tell us. You please wait for some time, Suparis, because basically to the Suparis, just wait for some time. Interesting topic is going on, let us. Please give your case number, Supari. Just give it to her so that, give a list. Or give a list to Mr. Bothapur. It will be a segment. Please, hardened part. Pass the order in state's appeal, item number 43, 45. List this hard in part, list this matter for further hearing on 14th of September 2023. Give all this common order.
21, 45, 46, 47,
May.
12 and 13.
12 and 13. What is 21, Mr. Bhattacharya? 21 is the Supari. 451, 21. You have it together, take together, all this common order.
Item 44 for Flashman.
Yes.
This year, the traffic was very challenge lossy. Already charges were very lossy. Some reports were converted on section 465, 468, 471, my lord, charges were there. That's we are not challenged. Only traffic was challenged, my lord. Was there,
Who was the petitioner?
Take certificate was. My lord. But in this case, petitioner protested the Panchayat election. And in the election, there are this information and this island affairs, taking the packet, submitted false certificate. I have announced my certificate and sheet and all, which federal this is I have passed my exam a lot. And therefore the FIR was with the petitioner is not correct.
Now, he says that Sarges has also been framed in the meantime.
Hello,
Sarges has also been framed. Any scan copies called in this case?
is there was. That's here. Other three flags are there, my lord. The important ones. And two was confirmed from the my lord. Already that report is in nothing particular. I think we will reflect everything. It is stated that the petitioners one academic certificate recording from here. I have exhibited all these documents, including my admission register and office, registration certificate, mark sheet, and certificate. And the petitioner, the government flag contested the election on behalf of the Lord from Congress party. This petitioner is independent candidate who win the election. And just out of
No, that can be a good ground. Let's see, otherwise you would not have her obstruction. But criminal case is a criminal case. Where in which page, Mr. Bhattacharya? Page 18 of the petition.
yes. Page 29. This is the certificate, provisional certificate, this is from the
Page 29.
Hmm.
Then when the next page, this is the mark sheet.
Problem is not that. Problem is not that. According to the search sheet, they contacted the university. University said there is no such things. Now, whether these are genuine or not, can this court under 482 decide? Tell us that. There are two dispute that this, the final certificate you have passed, they have taken statement of the registrar of some Sanskrit University. He said that this is not genuine. According to that may be genuine, it needs forensic examination, it needs cross examination. But can we decide that no, that his statement should be discarded? Your documents are correct. Can we do this in 482? You may have a good case. But can we decide that in 482 all these disputed questions? Tell us. How will we come to a conclusion that all these documents are genuine when a search sheet is filed saying that we collected, we went to the university from where he has claimed to be passed said that this is not genuine. Now, we'll have to say that this is genuine to allow your 482 petition. Now, then we'll have to have a box here. Then you and him will cross-examine. Is it permissible under 482? If not, then better to face the trial, properly cross-examine. They will have to exhibit all the documents and original documents and prove it is onus upon them to prove that your certificate is fake. They will have to send it to the this forensic, whether they have done it or not. Anything we comment, we will go against you. We will say prima facie case is made out. That will have an effect on the mind of the court.
I have all the documents, and I can.
Understand. You face the original result. Can I decide that this is not fake? That is not manufactured. Can this court decide under 482? That is the onus upon them to prove that these certificates are fake. That is that they will have to do either forensic or they will have to bring evidence. You will have chance to cross-examine. On what basis we will say that you are correct, they are not correct? Tell us in 482. If I have a power, we will do that. We are ready to do that. Understand, they filed an application to harass you. But a specific environment is made that your certificates are fake. Now police registered the FIR, investigated and filed a search sheet saying that we have collected these documents, also examined the register of the university who says this is fake. After that, if we will have to say that their FIR is mala fide, I will have to say that the statement of that man is incorrect. On what basis should I say? I will have to say that these your certificates are genuine. I can do that in 482 power in exercise under 482. Tell us, is it law? So should we observe all this? That so and so has stated, because we'll have to give reason or you withdraw this to face the trial properly and go there. This is the best way for you. If you are having the genuine, send it for forensic. You do.
Pending, proceeding is pending, or stay, that order is there.
We'll vacate the interim order. It's okay. Please this matter on 9th or 10th. On that date, the learned counsel for the petitioner shall obtain instruction whether to pursue this matter or face the trial as the charge has already been framed. You wait. This is difficult. We will have to make comment that we cannot comment. It's a prima facie case is made out. That thing we'll have to say in dismissing. And we cannot allow your petition. Yes.
48.
Affidavit, criminal petition, what is this? What is the challenge? Cognizance in NI procedure. You want to file a reply?
Yes.
What is your ground challenging? What is the ground? Or both were confident that this will be adjourned? That at 3:30 matter will be adjourned, so better not to prepare. Jurisdiction. So you'll go to the proper jurisdiction if there is no jurisdiction.
That petitioner is not necessarily part of the case, you can get that they are not a whole time director. But Your Honor, if we pursue the annexes that you annexed along with our opposition, it will clearly show that they have suppressed impedance fact. And in fact, the petitioner is a whole time director and is responsible for all the transactions that the company has conducted.
Okay, when? Tell us.
Your Honor, there's a stay of in operation, Your Honor. It's a humble request with a short date, period, 2028.
Short date will give, this matter should not be kept pending, but problem is that the date, so many cases we are fixing, yes, Musmi, possible, 25th,
Your Honor, a shorter date.
may not be possible. You may fix a date, but it may not be possible, it will be at 4:15, then there will be adjournment on 25th. As agreed to on the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed on 25th. 25th September. 25th to enable him to go through the affidavit in opposition filed by the petition. Filed by the respondent. Interim order pass earlier cell country. 49 and 50. But will not adjourn on that day. Please become prepared.
For hearing 51.
Yes, what is this? Yes. Under section 307. What is 307? Attempt to murder. Any injury? No, any injury, injured victim? Who is injured? PW2 is the injured victim. Who is the doctor? 7. And where is the exhibit medical report? Injury report, exhibit 1A. Now, any eyewitness? No eyewitness, only the victim. Who are the other witnesses? PW3? So he's the informant, he is not eyewitness. Okay. Now, who is PW3? He is hearsay. Okay. PW4 is the PW3 neighbor. She is also hearsay. where the incident took place.
Incident took place.
And who is PW6?
PW6 is the wife of PW4 pilot, also sniper.
Hearsay.
Yes.
So on, and who is PW8? IO. IO. Now tell me, we discard all these evidences. Say PW 3, 4, 5, 6, and PW1. Now let us first see the FIR. But this PW 3, 4, 5, and 6, did they say that they saw the injured person with injury?
Yes.
They said.
Yes.
So according to them, injury is established. Injury is established. So they have not seen the actual occurrence, but they have seen the injury. No have said. So they are, from their evidence at best, it is as it can be, we'll go through the later on, it can be said to be established that they saw PW2 injured.
Yes.
That much only, not beyond that. Okay. Now let us see the FIR. Page 1. Page 2. Actual Azhar. No. Where is the content? Page 4. Page 4, page 4. Yes. Huh? I'm having a paper book. Are you having a paper book? Huh? Okay, you share this paper book, both. Are you having a paper book? Okay. Then FIR you understand. Now, okay. Now let us come to the PW1. Page 8.
W2 is my younger brother, the accusation of the act is my neighbor, who is died at the same with my brother believed them. The first deadlock led to our residence with something with father, and I am the witness. I found that your father is not the best to get our residence. I don't think it could be at this time. That you attempted to step, I went to Beretta of my residence out of care of the by the exit. My younger brother came to know about the incident. So he out
Came out.
came out from the residence to declare the matter. Came outside from his building. The accused stepped him then and there. The accused performed their not speak that he had of the lift their not like to speak and pass there the chair at the neck of my younger brother, at the shoulder of my younger brother. At the left side of the shoulder. I reached the place of water immediately. The accused then after commission of
According to him, he is the eyewitness. No, we'll come to that. But in Sif, according to Sif, he is the eyewitness. The accused first attempted him, then when his brother came, according to him, we'll see the cross examination.
And I found lying my younger brother on the ground after. One witness also came to the place of settlement of this situation along with Sonimota. After them, Amani Detna and Komola Detna followed. I informed Tata to Taupura and Village together. To deal with them. Villager hired there was no enmity in between village and some quarrel. They had no quarreling also. It is not a fact that my younger brother did not endure at his working place. It is not a fact that Sampal did not share Vilishna in my presence. It is not a fact that he was out of therapy. I brought my brother to the police station and I also informed about the incident to the copy of the police station of the brother. What we hear of the brother recorded by statement on the incident, given by me. What we said my brother to the hospital for treatment and for medical examination after the incident. My brother believed that the sites from the distance of 5 hands from my residence. It was a fact that I did not see some work along with the PTSD and for the different day of the time. It's not a fact that I did not see the journal standing on the road at the time of incident. It's not a fact that out of the center.
But in cross-examination, there is not even a suggestion that you have not seen the incident. He's a witness. He's a witness. Thereafter,
Then minus will not be kindly his wife minor.
now forget about we have now come to the injured. We have got one eyewitness. Then let us see what the injured says. Hmm.
I know accused. The name of the accused is Sampal Devna. I filed the case against the accused Sampal Devna. The incident occurred 1.5 years. The incident occurred at 9:30 p.m. At that time, I was at my residence. My wife, Bhavani Devna, also present at my residence. The accused Sampal Devna came to my house at night. I went outside of my residence hearing
Calling.
calling to me by the accused Sampal Devna. The accused kept me at the left side of my head and just like near the left ear. I lost consciousness after the incident. I regained consciousness at hospital after 2 days of the blood came out from the hole and came wearing clothes. People is my clothes. Police is my clothes having blood stains at the time of injury. This sporting Genji and can are available before the court. My father paid filed the case against the case. I had no enemy to justice from what my elder brother resides in the northern side of my residence. The Gita system is southern side of my residence. There was a residence on the eastern side of my residence. However, I was named. My is not complete my job.
Civil lawyer as cross-examining.
However, I completely made the owner of the case. My elder brother resides at the western side of my residence. My residence faces towards the southern side. The residence of my elder brother, Sampal Devna, is situated at the western side. I need 20 minutes to reach the residence of Aboni from my residence by walking. Aboni resides in our village. But I am unable to say about the direction of this residence.
No further reading is required. Kindly come to I in cross-examination. What is the conviction period?
5 years.
5 years under 307. I opened the door of my residence. The accused stabbed at my head while I came near the door. I fell down on the ground. I became unconscious as a result of the incident. Cross-examination. What more you want? Motive is not there. He may be mad. There is no defense that he is a madman. He was under drunken condition. He is entitled for it. Where is the cross-examination?
I told you that it is a point, but nowhere it is quite listed.
See, there is no motive. Motive is not there. But it is established that the accused has injured his victim. That is established. PW1 is the eyewitness. Ignore all other witnesses. And PW2's injured witness always in a higher pedestal. So he affirmed it that how it was beaten, and that was reaffirmed in the cross-examination. Now, therefore, let us come to the doctor. If doctor says, what is the doctor says? Let us see that. Now, PW, that's why I asked PW8, PW7, page 21. Page 21. What is the punishment for grievous hurt? And 307? 307, 7 years. Anything that can be added to reduce something? What is the mastoid reason? That is why we are trying to give you. Vital organ. Heat is vital disorder. Exactly, it means. Yes, it is this part. Exactly, whatever he has said. This person. One is this person, 2 injuries. One is in the shoulder zone. 2 single, it's not even so single blow to give him some benefit. And then one is in a major portion. They're outside or inside? What is the penalty for this simple injury? 5, no? Simple injury. 325. What is 323? 325 is a grievous. Hmm. Hmm. Then what is?
Extend to 3 years, which may extend to
We'll give him 324.
years. Otherwise, on a 3/7, I'm sorry, 3/07 also, I think, imprisonment of life.
Life, up to the.
In case of heart,
Hmm.
then in other cases, up to 7.
See, here motive is not there. Dangerous weapon is there, but motive is not there. From no motive is there, and that he has an intention to kill. That is,
Otherwise, motive is not essential. Because
motive is not essential.
Because I specifically stated that when, he.
Vital, it should be vital organ.
Vital organ.
And he must have a knowledge that if it is hit properly, he will die. That is the 307.
And here, hardcore, then, imprisonment of, life.
Okay, who are the others are all hearsay, so will not read. Huh? Okay. That's why we'll go to the what is 324? Okay. So therefore we'll but we'll get this judgment on all subsequent. But again, it's a hard side. I'll just record the conclusion. From the aforesaid, this court can safely conclude the following. From the evidence of the PW1, from the evidence of PW1, and PW2, PW1, it is beyond reasonable doubt that PW1 was the eyewitness to the alleged incident. Full stop. 2. From the PW2, the injured victim and also injured victim, it is established that the appellant accused has voluntarily hurt the accused victim by a kukri, which is nothing but a dangerous weapon. And it is also established beyond reasonable doubt that the injury were inflicted in the soldier as well as in the soldier and in the left mastoid region. Left mastoid region. Full stop. From the evidence of PW7 and the medical report, it is clearly established that it is clearly established and beyond reasonable doubt that injury of one beyond reasonable doubt that one incised wound about 8 cm in the length of half cm in the left shoulder joint of the victim was found on examination. It was also established beyond reasonable doubt from the evidence of the PW7 doctor that another incised wound of 5 cm in length and half centimeter in depth was found over left mastoid region. The doctor evidence that the injury was caused by sharp cutting weapon also remain unshaken. However, the doctor opined that the injury are simple in nature. Injuries are simple in nature. In fact, during the cross-examination, the injured victim PW reaffirmed how, when, and where the injuries were inflicted by the accused appellant, and his statements are corroborated by the eyewitness PW1 and the evidence of the doctor PW7. From the evidence of PW3, PW4, PW5, and PW6, though they are not eyewitness to the actual incident, however, from their evidence, it is established that they found the victim in an injured condition, and the description of injury that they have given are similar to that given by the PW2, the injured victim, the PW1, the PW1 would indicate the informant, and PW7, the doctor. Therefore, it is established beyond reasonable doubt that while inflicting the injury, the accused has used and sharp weapon for stabbing and stabbed the victim. Such weapon of offense of stabbing or sharp cutting weapon, and such weapon is a dangerous weapon in the considered opinion of this court. From the aforesaid, it is also established that the accused voluntarily caused hurt to the victim by using a dangerous weapon, and such hurt has caused bodily injury to the injured victim. Therefore, in the considered opinion of this court, it is well established that the petitioner has committed an offense under section 324 IPC. However, this court, from the aforesaid evidence available on record, however, this court no lage, but however, from the materials available on record, it is not established that there was any motive, not to say any motive, to kill the victim by the accused. It is well established that the doctrine of mens rea has a significant application in the case under section 307. From the evidence in the considered opinion of this court, the nature of the act of the accused will not lead to a conclusion the conclusion that it was an attempt to murder. Section 307, in fact, is a failed attempt to committing a murder. Full stop. In the case in hand, from the evidence of the eyewitness as well as from the evidence and testimonies of the PW2, no such intention or overt action on the part of the accused is seen, which can lead to a conclusion beyond reasonable doubt that the attempt was the injury was inflicted with an intention to cause with an intention to murder the accused. In view of the aforesaid, this court is of the view that no case under section 307 is made out to convict the petitioner beyond reasonable doubt by the prosecution. However, as discussed herein above, the prosecution has been able to establish a case of conviction under section 324 IPC. Though section 324 IPC was not charged against the petitioner, however, it is also well settled that a lesser offense can be charged and punished subsequently during the trial, even if the charge is not framed and the charge is framed in an offense of with higher punishment. Accordingly, in view of the aforesaid decision, this court is of the view that the prosecution has been able to establish beyond reasonable doubt that the petitioner has committed an offense under section 324 IPC, and accordingly, this court is of the view that the punishment inflicted upon the petitioner of rigorous imprisonment of so and so, so and so, so and so is required to be reduced, and he is sentenced to undergo punishment of Mr. Bothakur 3 years under section 324. Full stop. The rest will give you be there for outside for some time. Definitely you are out. So that the period undergone so shall be set up after vacation, because it's a 2010 matter. Nothing is there. Disposed of. It's a judgment.
In 52,
I think we have completed our quota for today. What you say?
You know, the very short matter.
Short matter?
Yeah, yes. The other claim under 376 and 366A.
Mm.
Both did not find 376. and
Okay.
366A.
Yeah.
But convicted under section 363 for 2 years.
What is
If
C666?
you are taking away of minor or the custody of guardian, that is. And what is taking away that scholar will put in progress already without saying. We are taking away does not constitute that.
Whatever what you say,
Already 450.
already was written. Already was.
I'm not forcing you.
No, no, we will not be able to complete. We'll decide some other. We need more private secretaries if we'll have to do cases like this.
Yeah, so this is complicated list. You need to become more. So that.
बेटा, लाइन ले लगी है पागल के लिए. 26 now. I was thinking I'll not be able to finish. No other metal left. That too by 415.
Camera.